Good morning, all. I'm Dwight Keene. I'm chair of the Kansas Corporation Commission. I'm joined this morning by fellow commissioners Susan Duffy and Commissioner Andrew French. I'm convening this hearing on the non-unanimous settlement in the matter of the investigation into Evergy, Kansas Metro and Evergy, Kansas Central regarding the February 2021 winter weather events as contemplated by docket number 21-GIMX-303-MIS and docket number 21-EMKE-329-GIG. We are conducting this hearing by Zoom and broadcasting to the public on YouTube. So please bear with us if you experience some technical difficulties. Let's turn first this morning to the entries of appearance. And I'll begin first with Evergy.
Thank you. Good morning. Kathy Dingus on behalf of Evergy Kansas Central, Inc., Evergy Kansas South, Inc., and Evergy Metro, Inc.
Thank you. Curb.
Good morning. This is David Nickel. Let me try again. This is David Nickel. I'm Consumer Counsel for Curb. I'd like to also enter appearances for Joseph Astrab and Todd Love, attorneys for Curb. I will be the principal attorney involved this morning.
All right. Thank you, David. The KCC staff.
Good morning, Commissioners. Carly Massentine and Walker Hendricks appearing on behalf of Commission staff and the public generally.
Thank you. Capco.
Good morning. This is Susan Cunningham appearing on behalf of Kansas Electric Power Cooperative, Inc.
Good morning, Susan. Next, NGTCC and KIC.
Good morning, Commissioners. Good morning, all the council. This is Jim Zakor on behalf of KIC and the coalition. Also joining me today will be my colleague, Connor Thompson. Thank you.
Thank you. Coffeyville Resources, Refining and Marketing.
Good morning, Chairman Keene and Commissioners. Andrew Schulte on behalf of Coffeyville Resources, Refining and Marketing, or CVR for short. Also appearing today will be Frank Caro, who I believe is having some technical difficulties, but should be joining shortly.
Thank you. USD 259.
Yes, good morning, Your Honors. This is Tim McKee on behalf of USD 259, and with me this morning is David Banks.
Very well, thank you. Good morning. Does the staff have a recommendation regarding notice?
Yes. Excuse me. Staff has examined notice and reports that on March 3rd, 2022, the presiding officer in this matter released an order granting motion for procedural schedule. The order set a hearing for today, Wednesday, May 11th, in the event a settlement was reached by April 22nd, 2022. A settlement among KCC staff, Evergy, the Citizens Utility Ratepayer Board, and Kansas Electric Power Cooperative was reached and filed on April 22nd, 2022, indicating to all parties that the docket would proceed toward a hearing on today's date. The order was properly
Brian,
served.
I hate to interrupt, but our court reporter has lost connection. She's going to
Yes, hold off, if you.
So,
Robin, are you back with us?
She doesn't appear to be yet, so I guess we'll take a short break and have Carly probably repeat from the start. I'm not sure where the court reporter cut off. I don't see her on the screen yet. So,
and this is Frank Carroll. I got back on. For some reason, I got kicked off too, and I had to log back in.
All right. Welcome, Frank.
Thank
Michelle,
you, Chair.
Michelle, if you would let us know when Robin's back on.
Yes, she's going to try dialing in. She said she last heard the introduction for NGTCC, so we might have to back up just a hair to catch where she dropped off.
Go up to the top, where if you move this that we are seeing right now, I think we will be behind that on the Zoom. I think this is the public streaming.
I think we're getting audio from Tim McKee. If you could mute.
Yes, thank you.
Looks like somebody is dialing in right now, so that's presumably, hopefully the court reporter.
Yes, that should be the court reporter. And are you hearing us, Robin?
Michelle, if she is on the phone, does that create any problems if we go into breakout rooms for confidential information?
Will she be in the breakout room?
Yes,
with
we would
us?
need the court reporter to record the confidential information. My stenography is not that advanced.
No, she'll still be able to hear.
Okay, good. I just want to be sure that we didn't. Thank you.
And Robin, are you hearing us okay? We've got two of them.
Robin, this is Dwight Keene. I can see your image now.
She's on mute.
Could you, one at a time, Gary. Could you unmute Robin to see if we can hear you?
Okay, how's that?
It's much better.
Yes.
Much better. Okay, very good. Robin, I'm not exactly certain where it was that we lost you, but we were discussing notice at the time.
We left off when you were doing introductions, and I lost you at Mr. Zakura and Connor Thompson would have been entering their appearances.
Okay. We're going to back up just a little bit on these entries of appearance then. So if we'll do a redo from where we left off with KIC, and I'll turn to Coffeyville Resources, Refining and Marketing.
Yes, may it please the commission, on behalf of Coffeyville Resources, Refining and Marketing, Frank Caro and Andrew Schulte with the Polsinelli Law Firm.
All right, thank you, Andrew. USD 259. Tim, are you there?
I am here. Thank you, Your Honor. May it please the commission, Tim McKee, and with me this morning, David Banks on behalf of USD 259.
All right, thank you very much. I believe that does conclude the entries of appearance. My next question would be directed to the staff. Does the staff have a recommendation regarding notice?
Yes, Chair Keene. Staff has examined notice and reports that on March 3rd, 2022, the presiding officer in this matter released an order granting a motion for procedural schedule. And that order set a hearing for today in the event a settlement was reached by April 22nd, 2022. A settlement was in fact reached by certain members of the parties and was filed on April 22nd, 2022, indicating to all parties that the docket would proceed toward a hearing on today's date. Further, that order was properly served upon all parties in the docket 10 days prior to the proposed hearing date, which is consistent with the Kansas Administrative Procedure Act. The parties have subsequently conferred for a pre-hearing conference and engaged in communications relating to hearing procedure for a hearing on today's date. Therefore, staff recommends a finding of proper notice.
All right, thank you, Carly. Are there any objections to notice? Hearing none, I find that notice is proper and the commission has jurisdiction over this proceeding at this time and place. Before we turn to preliminary matters, let's review a few matters incidental to conducting these hearings via Zoom. First of all, if any party encounters any technical issue today, please go off the record so that we may resolve the technical issues off the record. Second, witnesses participating by Zoom are asked to keep their microphones muted when they are not scheduled to speak. Third, if the commission needs to deliberate, we will be going off the record, entering a Zoom breakout room where you can't see or hear us, and then we'll be returning thereafter. Fourth, since we have documents and information designated confidential under our protective order, the commission would appreciate the party's assistance in being extra vigilant about identifying when you are introducing or discussing confidential information so that we may ensure that only persons who have executed the proper NDAs or are eligible to receive confidential materials are able to hear that testimony. Toward that end, when we reach a point of testimony concerning confidential matters, we will utilize a special breakout room for that purpose so that confidential testimony may be presented among persons eligible to receive such testimony. And when concluded, we would then resume the public YouTube feed. So in essence, to summarize, we are going to try to utilize as necessary two Zoom breakout rooms, one for the purpose of commission deliberations, the second for the purpose of the consideration of confidential documents or testimony. Our IT staff, I believe, can assist us here in effecting these transitions, and we'll try to operate that as smoothly as we possibly can. I understand Evergy wishes to amend the procedural schedule and allow simultaneous post-hearing briefs and to also push back the date for a commission order. Ms. Dingus?
Yes, thank you, Chair Keen. Our proposal would be to set a date for simultaneous post-hearing briefs for May 27th, and then extend the deadline for the commission order to June 27th. I believe there was no objection from any of the parties when we made that proposal at the pre-hearing conference.
Very good. Is there any objection? Without objection, so any other preliminary matters we need to address this morning? Very well, we'll move on to procedure for the hearing.
I have a couple I would like to raise, Chair Keen. Yes.
All right.
I just need advice. Need advice from the commission on two items. As you know, we have KIC 1 through KIC 12 exhibits. They are produced from the Office of Governor pursuant to a Kansas Open Records Act request. I can speak to authentication of those documents at any time that the commission wishes me to do so, whether that would be at the beginning of the hearing or the beginning of the examination. I just need advice from the commission on how to handle that. The second item is yesterday afternoon, Evergy offered some items for judicial notice, and we would like to be heard on that issue prior to a ruling by the commission. Those are the only two things I have. Thank you.
With respect to the first matter, Mr. Zakura, the documents to which you refer, have those been pre-filed? You're on mute, Jim.
Excuse me, they have been distributed to all the parties last Friday.
Okay. Are you moving for their admission?
I will at the proper time, yes. And if you tell me now is the proper time, I will do that. And I can speak to the authentication of that as well.
Okay, please do.
Um,
I think you could summarize these things. I believe the parties have already
Certainly.
received. Sure.
Correct. The issue comes as to the authentication of those being authenticated by the Office of Governor. And we have an email where they were all sent to us by the Office of Governor, sent to me by the Office of Governor on November 8th. And then there is on Monday of this week from the Chief Counsel of the Governor. He indicated that the office does not provide affidavits, but that in his opinion, it would be sufficient that since they carry the email address of the Office of Governor, that is appropriate authentication for those documents. And I don't think, if anyone objects, I have not heard it yet, but I don't know either way, that we have done our best to authenticate those as being appropriate and authenticated by the office.
Is there any objection to the admission of these documents?
Staff would raise.
Hearing none, they're admitted. I'm sorry.
I apologize,
Ms.
Chair.
Hazelton?
I apologize, Chair Keen. I'm dealing with two feeds right now, and sometimes I unmute the one that causes an echo. So I apologize for that. Staff would object to the admission of these documents at this time only because we find them to be duplicative. If they are meant to prove a call for conservation from the governor's office, I believe that the emergency order that was issued by the governor, as well as the emergency order that was issued by the commission, both will cover that and state that the governor did call for conservation across the board.
May I speak to that? May I speak to that point?
You may. Just as occur.
The fact that they may be duplicative or not is not a proper objection to authenticity. And the documents do speak for themselves. They are not duplicative. They come from various people in the Office of Governor, and they're being offered for the purpose of showing the coordinated response, which certainly our group supports, of conservation throughout this period. And we would like to have a full record of that, including those documents that are listed as KIC 1-12. And KIC 1A, Chair, is the authentication from the Chief Counsel of the Governor. So we would move that those be authenticated and moved into evidence.
This is Dave Nickel. May I also speak to that?
You may.
Thank you. I would join with staff's objection to this. That truly, Mr. Zakur did try to authenticate these documents at the very last moment, was not able to do so. They are not truly authenticated under Kansas rules of evidence. And we deem they're redacted heavily in certain areas. We don't know whether they're true and correct copies. There's nothing to indicate that they're true and correct copies. And so we would join in staff's objection to this point. We don't believe that Mr. Zakura has met the rules of evidence with regard to these exhibits, and we don't believe that they should be admitted at this time.
Mr.
May I
Zakura?
speak to that, Chair? I would call attention to the commission to KSA 60-465, and that is authentication of public documents, self-authenticating evidence. It gives the commission discretion as to whether on view they deem the authentication and the documents to be authentic. It also talks about extrinsic evidence of authenticity as a condition. It is not required, but however, we did provide that through the Office of General Counsel. The redactions are not made by me. The redactions come from the governor's office, and the documents have not been at all changed. They're as they came from the office of the counsel of the governor of the state of Kansas, and that is so stated by both Kathleen, I don't know how to pronounce her last name, Haug, and also by the chief counsel, which is Mr. Justin Witten. those documents are exactly as they were presented to us. And the office of the governor did whatever redactions they felt were appropriate under Kansas Open Records Act.
I'm going to overrule these objections. Are there other objections? Very well. We will admit these documents. The commission can assign at the appropriate time whatever weight it wishes to these documents and to consider them within the scope of the totality of the evidence that's presented. Are there any other preliminary matters we need to address? I'm sorry, Mr. Sakura, you had a second matter you brought to my attention.
Chair Keen, before we do that, I just want to ensure that we have a clean record. And I know Mr. Zakora introduced a batch of documents. I just want to be sure that we have the correct number of documents that were just admitted, so there's no dispute later.
That's fair enough.
Yes,
Mr. Zakora, let me ask this. Some of the, at least one of the, I think I'm looking at the cover transmittal from you dated May 6th.
Yes.
I think it alludes to some, I think it was 24 documents. And yet I recall you having referred to 12. Am I confused there?
Chair, the only 12, the only ones that come from the governor's office for authentication, Chair Keen and Mr. Fedotin, are KIC 1, 1A through KIC 12. Those are the only documents that come from the office of the governor. The remainder of the documents, most of those documents, were previously attached to the testimony of Mr. Ives in a proceeding over in Missouri, and they can be authenticated through Mr. Ives. So Mr. Fedotin, I am only talking about KIC 1, KIC 1A through 12.
Okay, thank you. So that helps, Jim. Thanks.
Okay, I appreciate that clarification as well. Are we good to go, Brian?
I believe we can move on to Mr. Zakora's next item. Yes.
Okay. All right. Very good. Okay. Are there any other preliminary matters to address? Oh, there is. I'm sorry. Get kind of sidetracked here a bit. You had one other matter, I think, Mr. Zakura, that you proffered.
Chair Keen, if I may, I believe it was with respect to some of the documents that I had emailed the parties yesterday, some of which we intend to request administrative notice of. I have not made that request yet. I was intending to do it during cross-examination of Mr. Gorman, and I would suggest that's the appropriate time to take up any discussion of those documents.
Very well. I appreciate that. Could we defer that, Jim?
That is fine with me. I just would like to be heard on the issue at whatever appropriate time the commission deems that I may be heard.
Right. Thank you, Ms. Dingus, for that clarification. We will defer in accordance with your wishes, Ms. Dingus. Are there any other preliminary matters? All right, then we'll move on to the procedure for the hearing. I understand that the parties wish to make opening statements. Evergy will go first, followed by CURB, NGTCC, and KIC, Coffeyville Resources, USD 259, and then the KCC staff. After opening statements, we will follow the order of witnesses that were agreed to in the pre-hearing conference. I understand that at the pre-hearing conference, the parties indicated they will not make closing statements and that we will also have a procedural schedule that allows for post-hearing briefs, and certainly we've already addressed that issue. Let's turn now to the opening statements, and we'll begin with Evergy. Ms. Dingus, please.
Thank you, Chair Keen. Is it okay if I share my screen?
Absolutely.
Great. Let me see if I can get that to work. Are the commissioners able to see that?
Nothing has come up yet. Yes, it is. We're good to go.
Great. Okay, thank you. Mr. Chairman and Commissioners, good morning. On behalf of Evergy, we are pleased to be able to present to you a settlement of the Winter Storm Uri related matters at issue in this docket that will result in just and reasonable rates for Evergy's customers. The settlement is in the public interest because it allows the costs and benefits associated with Winter Storm Uri to flow through to customers in a timely manner with minimal impact to their bills. I know the commission is probably very familiar at this point with the details of what happened during this extraordinary event, so I won't repeat those details now. Specific to Evergy, Evergy Kansas Central incurred extraordinary fuel, purchase power, and non-fuel O&M expenses as a result of Winter Storm Uri that have been deferred as a regulatory asset pursuant to prior commission order. On the other hand, for Evergy Kansas Metro, off-system sales offset the costs incurred for Winter Storm Uri, and a regulatory liability was created to provide that benefit back to customers. I know you're also familiar with the terms of the settlement agreement filed in the docket, so I won't review those in detail either, although they are reflected in the slides I'm going through on the screen, and I'm happy to address any clarifying questions the commissioners might have about the terms. One item I do think is important to clarify is the allocation method that would be utilized under the settlement agreement, because there seems to be some confusion over that in testimony and pleadings filed in opposition. Under the settlement agreement, Evergy Kansas Central's regulatory asset would be recovered through its RECA, which means there would be a set per kWh rate calculated based on actual usage in 2022 and applied to all customers based on their actual usage each month beginning in April 23. Although Evergy did provide the parties with projections of usage by class for 2022 in order to help them evaluate the impact of the settlement, those projections will not be the basis for the allocation of the regulatory asset to the classes. The rates implemented under the settlement agreement will be just and reasonable for Evergy Kansas Central because first, with respect to the allocation of costs among customers, as I just explained, the settlement agreement provides that the regulatory asset should be recovered through the RECA. This is reasonable because it is consistent with the method under which these costs would have been recovered absent the commission order requiring deferral. Second, the amortization period of 2 years is also reasonable. This amortization period ensures that the costs will be recovered from customers as close to the time they were actually incurred as possible and helps to prevent concerns about intergenerational inequities. Moreover, Evergy has agreed to apply carrying charges at a very low rate of 1%, which significantly differs from the carrying costs allowed by the commission in its emergency order authorizing deferral. And carrying charges will only be applied through the period of time before we begin to recover the costs, and not the entire period deferred amounts are outstanding. As Mr. Ives testified, the reduction in carrying charges from the weighted average cost of capital authorized in the emergency order to 1% agreed to in the settlement saves customers approximately $32.2 million in interest. Finally, the 1% interest rate is significantly lower than the carrying charges agreed to and approved for other utilities in Kansas. For example, Kansas Gas Service and Atmos are applying rates double the 1% rate. Southern Pioneer is charging a rate of 2.14%, and Black Hills a rate of 5.71% over a 5-year period. As Mr. Ives and Mr. Grady testified, the impact of the settlement agreement on the average residential customer served by Evergy Kansas Central will be about $2.82 per month for the 2-year amortization period. This compares very reasonably to the cost impact of other settlements approved by the commission and found to be in the public interest. For example, the impact of Southern Pioneer's settlement is expected to be about $7.89 a month, and the impact of Black Hills agreement is expected to be $11.47 a month. The rates implemented under the settlement agreement will be just and reasonable for Evergy Kansas Metro because the settlement agreement returns the benefit accrued as a regulatory liability to customers over 1 year through the RECA, ensuring that they receive the benefits as soon as possible. It applies the same carrying charge that is being applied to Evergy Kansas Central's regulatory asset. Additionally, the settlement agreement does not offset the regulatory liability with the amount of under recovery as a result of allocation issues at this time, but instead defers consideration of that amount and of the allocation issue to the upcoming general rate case. It also provides that the parties will work in advance of that rate case to attempt to resolve the issue together with Missouri Commission staff. An average customer on Evergy Kansas Metro system will benefit by about $6.60 per month over the 1-year amortization period. For both Evergy Kansas Central and Evergy Kansas Metro, the settlement agreement ensures that any future recovery for Winter Storm Uri related items will be returned to customers through the RECA whenever such recovery occurs, even if it is after the amortization periods are complete. The settlement agreement is supported by Evergy staff, CURB, and KEPCO, but is opposed by KIC and its participating members, Coffeyville Resources, and USD 259. Based on the testimony Mr. Gorman filed on behalf of these parties, we understand they oppose the allocation of Evergy Kansas Central's regulatory asset through the RECA and the amortization period agreed to in the settlement. With respect to the allocation issue, they argue that the costs recorded in the regulatory asset should be allocated to customer classes based on their usage between February 12th and 16th of 2021, because such an allocation would reward customers who responded to requests from the governor and commission for curtailments during the event. There are numerous problems with this proposal. First, Mr. Gorman picks 5 days out of the month and argues they are the relevant days for cost allocation, when the storm impacted costs over a much longer period of time. Second, the KIC proposal would essentially impose a retroactive charge by customer class for these extraordinary costs based on how some customers within a class may or may not have responded to conservation requests. Isolating 5 days out of a month and using that usage data to charge customers for Winter Storm Uri costs would be similar to retroactively implementing a time of use rate for those customers without providing them any notice. The fact is that, as Mr. Ives testified, there were customers within each class that reduced their usage during the event, both voluntarily and as a result of the rolling outages required by SPP. I know that my family was directly affected by an outage, and I'm sure that you all know individuals and small businesses who were impacted as well. While some of the customers in the ILP, LGS, and special contract classes may have reduced usage, numerous others did not. In fact, several of the customers participating through KIC in this docket declined to reduce their usage when asked, reduced less than asked, or in at least one case, reduced their usage less than the contract called for. Excuse me, and the usage for the schools class was essentially flat during the event. For certain of the larger customers, it appears that some usage reduction was forced by natural gas curtailments, not as a result of heating calls for electricity conservation. Mr. Gorman's proposal to reward large customers for the behavior of a limited number of customers in a class and penalize residential and small general service customers when many of them in fact did make efforts to reduce usage will have the opposite impact from what he claims to be the goal. It would not be consistent with principles of cost causation and instead would disincentivize residential and small general service customers from making efforts to conserve when requested in the future. Mr. Gorman's proposal would treat these deferred costs different from how costs are recovered through all of Evergy's riders, none of which apply a retroactive look back at usage for allocation of costs, or in other words, employ a retroactive time of use allocation methodology. As I indicated before, the costs in the regulatory asset would have flowed through the RECA absent the deferral order, and it is reasonable for that to be the recovery method now as well. Another consequence of this non-standard treatment would be that customers who are not currently billed under Evergy's RECA, such as one of our special contract customers and those on the Direct Renewable Participation Service, or DRPS tariff, would have to be allocated a portion of the cost from the event if a separate line item were to be approved. An additional concern with KIC's proposal to utilize a separate line item is that, as Mr. Grady testified, there are substantial costs associated with adding a line item to customers' bills. Evergy would incur IT and other administrative costs, auditing costs, and customer education costs in order to implement the new line item. And it would take a significant amount of time to put this into place. And in the end, the separate line item would likely cause confusion for customers because it wouldn't appear on their bills until over 2 years after Winter Storm Uri occurred. With respect to the amortization period, Mr. Gorman proposes to extend the period from 2 to 3 years, primarily because he argues that is what was approved for Southern Pioneer. Mr. Gorman ignores the fact that even with a 2-year amortization period, the expected impact for an average residential customer on Evergy Kansas Central system is $2.82, which is significantly lower than the expected impact of $7.89 for Southern Pioneer customers over their approved 3-year period. The shorter amortization period is consistent with the carrying costs agreed to by Evergy, which, as I indicated before, are substantially lower than the carrying costs already approved for other Kansas utilities. As Mr. Ives testified, a longer amortization period would require a higher interest rate, which would mean additional interest costs for customers. It would also separate recovery of the costs from the customers who were on the system when the event occurred. Even under the settlement agreement, because recovery doesn't begin until next April and goes for 2 years after that, full recovery won't occur until 4 years after the event. Extending the time period for recovery beyond that is not reasonable. The final argument Mr. Gorman makes is an extreme and unsupported suggestion that the commission should look at residential usage in isolation for a 5-day period in February of 21 and compare it to residential usage on other days in February to calculate an alleged windfall that he wants to use to offset the regulatory asset. This attempt at single issue rate making is unreasonable and illogical. Mr. Gorman didn't compare the residential class usage to February usage in any other year or to the usage during the test year, which is what rates were based on. Despite the fact that he contends other customer classes were able to make reductions in their usage during these days, Mr. Gorman doesn't aggregate the usage of all the classes to determine the impact to the company during those dates. He just looks at the class that conveniently supports his narrative in complete isolation and suggests an adjustment based on that. Mr. Gorman also fails to look at other events that may have occurred in 2021 that might have impacted the company's revenues. And he completely ignores the fact that Evergy Kansas Central recently filed its earnings review and sharing plan compliance filing, which clearly indicated that the company did not over-earn or experience the asserted windfall for calendar year 2021. Mr. Gorman's proposed offset based on residential usage is certainly tailored to support his position that residential and small general service customers should shoulder a greater impact from Winter Storm Uri to the benefit of the customers he represents. Some of the largest His proposal is clearly an extreme form of single issue rate making and should be disregarded entirely. Mr. Ives and the other witnesses testifying in support of the settlement explain how the agreement meets the 5-factor test that the commission typically applies. As a result, we respectfully request that the commission approve the settlement as it has been submitted. Thank you.
Thank you, Ms. Negus. If we could remove the screen share now, please.
I am working on it. I think that worked, okay. Hopefully, if I hit the right button.
It worked. You did well. Thank you.
Great. Sure.
I'm trying. Very well. For the next opening statement, we'll turn to Curb and David Nickel.
Thank you. May it please the commission. Winter Storm Uri was an unprecedented and extreme weather event in Kansas. The governor's February 14, 2021 declaration of emergency warned us about the extreme temperatures and supply issues and asked Kansans to conserve. The commission's February 15, 2021 emergency order directed utilities to do what it was necessary to ensure reliability during the storm and directed consumers to do what they could to conserve energy. The evidence shows that Evergy performed ably in meeting the commission's directive. Yet CURB perceives that the consumers, Kansas residential consumers, also did what they could to conserve energy. According to Webster's dictionary, conserve means to keep something in a safe state, that is, to avoid the wasteful use of a resource. The implication that residential consumers wasted electricity during Winter Storm Uri is offensive. Personally, we kept our heat low, sealed our doors and windows, turned off lights. We used blankets and coats to keep warm during that period of time. I believe the commissioners also did the same, as well as CURB staff and the KCC staff. Do you think we are the only Kansans that did their best to conserve during this period of time? In fact, we believe that Kansans largely did what they needed to do and was asked for them to do by both the governor and by the KCC. The governor's declaration and the KCC order called all Kansans to work together for the common good throughout the winter storm. As Commissioner Duffy said in the February 15, 2021 commission meeting, we are all in this together, and we succeeded together. Reliability was maintained throughout the storm. That fact is supported by the staff's R&R, and it wasn't 1 or 2 or 30 of us. It was the majority, the vast majority of us working together. True, the energy use is up during that period of time due to extreme temperatures that lasted over 10 days. But I believe consumers used less than they could have. All consumer classes conserved, as shown by the testimony of Darren Ives. By conservation efforts among all classes, Evergy's costs were likely lower than they could have been had consumers not turned their thermostats down, turned off unnecessary lights, and otherwise conserved electricity. It is not a surprise that many Kansans pulled together in the winter storm, as they do in other dire circumstances. It's what Kansans do. First responders risk their lives to help others in dire need. Kansas military fights for our freedom, not just merely for theirs. Common citizens leave their jobs and help others when severe weather such as tornadoes or floods or other natural disasters strike. Yet none of these heroes ask for reward. None of them at the end of their service in aid of others ask to be paid. Nobody asks to be made whole, except for a handful of industrial customers in this case. They feel punished if they are not made completely whole for the sacrifices they were called to make. It is not enough that Kansas had reliability throughout Winter Storm Uri. It is not enough that we did not lose lives or have catastrophic damage as Texas did. Doesn't matter whether or not low-income customers at this point can't afford their bill as it is. We should add a little bit more burden. After all, they caused the problems. Rather, to read the KCC's order or the governor's order as ordering some type of cost-based recovery scheme is perverse. What those orders do is called for all of us to be better versions of ourselves, to do what we could to help in that situation. And I believe largely Kansas residential consumers and small business consumers did what they could in those regards, not worrying whether their neighbors did the same. They did what they could. And at the end of the day, after all the winter event was resolved and over, the Kansas residential consumers and small business consumers worked with Evergy and the commission staff to resolve the final element of this puzzle, and that is to work through the cost recovery. We worked through the efforts that Evergy did with regard to keeping the lights on during the storm, and determined that their cost that they incurred and the measures that they took were reasonable. We looked for a reasonable period of time by which those costs could be recovered with minimal impact on consumers at 2 years. And we negotiated the lowest carrying cost of all utilities in the state of Kansas with regard to this event. We accepted the RECA as the proper way to collect these costs. And we agreed with staff and Evergy with regard to certain matters that needed to be improved in the future. As a result of all these negotiations, we ended up with a non-unanimous settlement agreement. The issue in this case is simply whether or not that unanimous settlement agreement should be approved by the commission. And the commission is familiar with the 5 factors that are used by the commission to determine whether non-unanimous settlement agreements should be approved. The first is whether or not the settlement agreement complies with Kansas law. It does. The application was filed, the compliance report was filed in accordance with the commission's orders and the Public Utilities Act. The proceedings in this comply with the Kansas Corporation Commission's rules and regulations, as well as the Kansas Administrative Procedure Act. And the settlement agreement in all, if reasonable and determined by the commission, is a favorite of the law. The second factor is whether or not the parties have had an opportunity to be heard in opposition to the settlement agreement. The compliance report was filed on July 9th, 2021, over 9 months ago. There has been an ample opportunity for discovery through DRs and otherwise. There have been ample opportunities to discuss this matter among the parties to this proceeding. Every party had an opportunity to file testimony in this matter, and that testimony is being heard today. And after this hearing, post-hearing briefs will be filed parties have the opportunity to file post-hearing briefs in this matter. There was ample opportunity for opposition parties to be heard in this matter. The third element or factor that the commission uses to determine whether a non-unanimous settlement agreement is reasonable is whether or not there is substantial and competent evidence to support it. The evidence of Darren Ives, Evergy's witness, Darren Ives and Ron Clote speak extensively as to the efforts that Evergy went through to keep our system reliable during Winter Storm Uri and the costs that they incurred. The testimony of Evergy's witness and staff's witness go to the reasonableness of the 2-year period of time in which these costs will be recovered from Evergy ratepayers. All witnesses testify in support of the low interest rate that is set forth in the settlement agreement. Evergy's witness, Darren Ives, and Justin Grady, KCC's witness, talk to the reasonableness of the RECA to collect these costs. And the KCC's witnesses and Evergy's witnesses speak to the improvements that need to be made. So there is substantial and competent evidence in the record which supports the non-unanimous settlement agreement. And as to the fourth element, the settlement agreement is certainly in the public interest. There is wide public interest in keeping our system reliable during the winter storm. And the evidence shows that Evergy worked hard and consumers worked hard to make sure that happened. The quid pro quo of that is that we need to make sure that our Evergy has the opportunity to recover the costs that they incurred in meeting that public obligation. And the evidence supports that amount will be done in a reasonable manner as set forth in the testimony of the various witnesses. So in this case, the public interest was met. Finally, this settlement agreement will result in just and reasonable rates. As Ms. Dingus indicated, the amount that will be collected from consumers is about $2.80 per month over the next 2 years, in comparison to what could have occurred if this matter was heard just strictly through the RECA and the time frame set forth. Frankly speaking, this is the lowest interest rate of all the utilities, and it's the least impact of all utilities with regard to this matter. As for the RECA, it is the applicable tariff in this matter. The tariff the RECA is intended to catch fuel cost, energy cost that Evergy absorbs, and it should be used for that purpose. It is the applicable rule. I'm aware that there are certain customers that'll go to a buffet and they'll, maybe after they finished a half a plate of food, will complain that they only ate a half a plate of food while others ate more, and ask for their price to be adjusted because they didn't eat as much as the normal customer. They want to change the rules of the game after the fact. In this case, the RECA is the applicable rule. The handful of industrial customers that are complaining in this case went into this event eyes wide open. They knew RECA was the applicable tariff. It is not necessary to change that rule now. The non-unanimous settlement agreement meets the 5 factors that the commission requires for approval, and CURB would request that the commission approve the same. Thank you.
Thank you very much, Mr. Nickel. Right for the next opening statement, it will be on behalf of NGTCC and KIC. Mr. Zakura, please.
Thank you. May it please the commissioners. Good morning. I am Jim Zakura of the law firm of Smithyman and Zakura, and I'm appearing before the commission today on behalf of the Kansas Industrial Consumers Group, known as KIC, and its participating members, and the Natural Gas Transportation Customer Coalition, the coalition and its participating members. In my opening statement, I will do my best not to denigrate any other party's position. I do not think that that's productive or helpful. I will try to stick as best I can to the facts and to precedent of the commission with regard to cost assignment and cost payment. The participating members of KIC and the coalition are from the entire cross-section of electric and natural gas customers in Kansas. They're not the few large industrial consumers that were alluded to earlier. Members include both small and large businesses, public and private school districts throughout Kansas, the faith community made up of multiple denominations, care centers for the disabled and the elderly, universities and medical schools, hospitals, government units, not-for-profit institutions, such as museums and recreation centers. Regarding natural gas and electric supply and price in 2021, almost everything that could go wrong did in fact go wrong. Rolling blackouts occurred and energy prices skyrocketed to levels not seen before. In February 2021, cascading failure of supply and high prices, the only countermeasure that worked, that was successful, was energy conservation. Energy conservation saved the day, saved lives of Kansans, and made a terrible situation less terrible. As a public policy tool to address this crisis, conservation was very successful. Businesses, schools, government agencies, churches, and not-for-profits heeded the call for conservation. The conservation efforts of the Wichita Public Schools are noted in an affidavit to the testimony of Mr. Gorman. This commission was a leader in the conservation effort that was so beneficial for Kansas, but it was not alone in that effort. In fact, the conservation effort was part of a coordinated state government response that was led by our governor, the Honorable Laura Kelly, the commission, and also included the Adjutant General of the Kansas National Guard, who serves as Director of Emergency Management for Kansas and Homeland Security. All Kansans should offer their thanks to the commission, the governor, and the Adjutant General for their leadership during this time period, and particularly their focus on conservation. The governor, the commission, and the Adjutant General appeared together at press conferences, broadcast on television and radio, and presented a unified message of state policy to the print media. On February 14, Governor Kelly made one of her several public appeals for conservation. If I may quote, "As the extreme cold temperatures continue to affect the region, we are urging Kansans to conserve energy in order to help ensure a continued supply of natural gas and electricity and keep their own personal costs down." Governor Kelly said. Speaking on behalf of the commission in the KCC media release dated February 15, 2021, Commissioner French stated, "It's in every Kansan's best interest to conserve electricity and natural gas over the next few days, when possible," said KCC Chairperson Andrew French. "Reducing your usage will help ensure everyone continues to receive these services, and it will save you money on future electric utility bills." KIC and the coalition are not here today to contest the additional costs that Evergy Kansas Central has presented as appropriate for pass-through to the customers. KIC and the coalition take no position on that issue. We are here in opposition to the non-unanimous settlement agreement because that agreement does not make an appropriate cost assignment to those classes that caused additional costs to be incurred and benefited from those additional costs in the period of February 12 to 16, 2021. In fact, the agreement makes no attempt whatsoever to assign recovery of the additional costs to those customer rate classifications that caused and benefited from the additional costs incurred. Under the non-unanimous settlement agreement, the additional costs will be recovered in the future as randomly collected energy costs simply based on annual purchases and whatever amount might be the case beginning in 2023. This is the juxtaposition of the parties regarding the recovery of additional costs. Evergy has provided, I want to say a compliment to Evergy here. Evergy has provided the precise amount of usage by each customer class, rate class, in the period of February 12 to 16, 2021. This customer class usage of the additional Evergy costs is set forth in the page 9 testimony of Mr. Gorman. This is the exact category breakdown of those customer costs that incurred and benefited from the additional costs. This is without question the best evidence. In fact, it's the only evidence of what occurred in the additional cost period of February 12 to 16. KIC and coalition members request that the commission follow its longtime precedent of assigning cost recovery obligations to those customer rate classes that caused such costs to be incurred and benefited therefrom. The non-unanimous settlement agreement does not reference the period of additional costs or account for the customer rate classes that caused the additional costs to be incurred and benefited from them, but instead simply throws the additional costs into the annual costs that will be covered under the energy cost adjustment beginning in March 2023. During February 12 to 16, 2021, the usage of large general service class was 14.87%. But under the non-unanimous settlement agreement, this class of customer will pay a far greater share of the Evergy additional costs. During February 12 to 16, 2021, the usage of the medium general service class was 10.34%. But under the non-unanimous settlement agreement, this class customer will pay a far greater share of the Evergy additional costs. During February 12 to 16, 2021, the usage of the residential service class was 46.07%. But under the non-unanimous settlement agreement, this class of customer will pay a far smaller share of the Evergy additional costs. The agreement provides that the recovery of Evergy additional costs will be through the energy cost adjustment, which generally affects the volumetric usage by customer class throughout a 12-month period. The percentage volume period usage by the residential class customer, as reflected in the Evergy SEC annual reports, are as follows: 2021, 34.17%, 2020, 34.88%, 2019, 33.16%, 2018, 33.89%. While these prior year percentage volumes are not for the period beginning March 2023, there is no credible evidence in this record that the volume of residential use in that future period will be anywhere close to 46.07%. The effect of the agreement's additional cost recovery method not only is a subsidy to the residential class, but further acts as a penalty for all those that conserved energy at the request of the governor and the commission. KIC and the commission do not believe that the joint movements recovery method complies with applicable law or commission precedent, as specifically noted in the Southern Pioneer case, where the commission stated, since costs are allocated based on individual usage, customers who conserved energy during the winter storm will see lower rates for their efforts. As the testimony of Mr. Gorman indicates, the recovery method of the joint movements causes subsidy in the amount of about $15 million that will negatively affect all the members of KIC and the coalition. However, there is a larger policy issue at stake. The governor and the commission set forth policy in this energy crisis. Conserve energy and it will reduce your costs. There was no parsing of words by either the governor or the commission. The message was clear and direct. Energy conservation during an energy crisis is a powerful tool to address shortages and high prices. It is sound policy. The most important policy risk to our state, if the commission approves the non-unanimous settlement agreement, is this. If the commission does not give economic recognition to those entities which positively responded to the plea for conservation from the governor and the commission, those entities will likely be less willing to positively respond to any future plea for energy conservation. The governor and the commission lose a powerful tool to address any future energy crisis. It is critically important to remember, and this is a really important point, that the governor did not order the Kansas schools be closed February 12 to 16, 2021. The governor did not order non-essential businesses to be closed during that period. The conservation response to the governor and the commission from the schools and privately owned businesses in Kansas was voluntary. That voluntary response, everyone pulling together in a crisis, is unnecessarily placed at great risk by the non-unanimous settlement agreement that unfairly allocates recovery cost. That agreement should be rejected by the commission. Thank you very much.
Thank you, Jim. The next opening statement will be on behalf of Coffeyville Resources. And I believe the presenter is Frank Caro.
Yes, Chairman King, thank you. And thanks on behalf of Coffeyville Resources, Refining and Marketing. This is Frank Caro with the Polsinelli Law Firm making this opening statement. First, let me say that because of technology difficulties, I'm not going to turn on my screen here and see my face, but that's probably a benefit to all of you that would have to be tortured by the view of me. Let me start by saying thank you so much to the commission for its review of these costs and the impact that this storm had. And thanks to the commission, the customers, the commission staff, the company, CURB, and everyone that got involved and lent a hand here, and to make sure that the system reliability was maintained during this awful storm. It took everyone's work to keep the lights on and the power flowing, and we appreciate that. A little bit of background about CVR. CVR operates an oil refinery in Coffeyville, Kansas, and has been doing so since 1906, over 120 years. That's in Southeast Kansas. CVR employs approximately 500 employees in Kansas facilities between its refinery served by Evergy, and then literally just across the street, the nitrogen fertilizer plant served by the city of Coffeyville, Kansas, that municipal utility. It just so happens to be that those rates from the city of Coffeyville are 1.5 to 2 times lower than the Evergy rates. These two CVR facilities are the economic engines in Southeast Kansas. As one of the largest industrial customers of Evergy's Kansas Central unit, the cost associated with Evergy's extraordinary expense has a significant impact on CVR. CVR supports the recovery of the settlement costs incurred by Evergy, but we do not support the cost allocation among the rate classes. As set forth by Mr. Gorman in his testimony, that cost allocation proposed by the settlement is based on a hypothetical usage by rate classes with no reality to the actual usage of the customers on the system. The numbers Mr. Gorman presents in his testimony are based on actual usage at the time of Storm Uri and takes into account curtailments and conservation efforts to reduce production facilities at these industrial and commercial plants. We also support the extension of the recovery of the Storm Uri costs from 2 to 3 years because we are sensitive to the impact on residential customers. Fairness dictates that the commission allocate the costs according to how those costs were incurred. Fairness also dictates that those who curtailed usage in order to support the electric system should not now have to pay again for power service it curtailed. The impact of the settlement proposed based on the proposed cost allocation in the settlement is over $1.3 million per year to CVR, which is nearly 150% of the increase in cost CVR's actual usage set forth in its rate class. We asked the commission to reject that portion of the settlement and find that the cost allocation proposed by Mr. Gorman's testimony as an alternative be adopted. Thank you for your time and consideration.
Thank you, Mr. Caro.
Chair Keen,
Yes.
may I ask Mr. Caro one question?
Who's speaking?
This is Commissioner
I'm sorry.
French.
Yes, certainly.
Mr. Caro, I don't believe you filed, your party filed testimony in response to the settlement. Correct me if I'm wrong, but it sounds like you support the testimony of Mr. Gorman. Can you just identify for me whether there is anything in his testimony that you do not support? Just if we're not going to hear from you again, I would appreciate knowing the CVR position.
Yeah, we did file a written objection to the non-unanimous settlement agreement filed on April 22nd, and we joined in that. We did not join in the testimony filed by Mr. Gorman. We do support that testimony and it filed by him. And I think he's given the commission some alternatives in that testimony to lessen the impact on residential customers if those costs are borne the way they were actually used during the time of Storm Uri. So we do support that.
Okay, thank you, Mr. Caro, and thank you, Chair Keen, for the indulgence.
Thank you, Commissioner.
Chair Keen, this is Brian Fidot, and I have I'm sorry to interrupt, a follow-up kind of on that, because at the pre-hearing conference, I understood that CVR had a slightly different position than Mr. Gorman was advancing, and that so CVR was going to get a limited cross-examination of Mr. Gorman. Based on what I just heard, it sounds like CVR is not entitled to cross-examine Mr. Gorman. So I want to get that clear at this point. Maybe I misunderstood what happened at the pre-hearing conference, or maybe I just misunderstood what happened here.
No, Mr. Fedot, and you are correct. If I can answer that, you are correct. And I notified Mr. Zakora, I believe yesterday, that we've reevaluated the position of Mr. Gorman, and we support that position, and we will waive cross on Mr. Gorman.
Thank you for that clarification, Frank, and sorry for the interruption, commissioners.
No, thank you.
Oh, it's all helpful. I think it'll help the process as we move forward. Thank you, Frank, for your clarification as well. The next opening statement will be for USD 259, Tim McKee.
Yes, Your Honor, thank you. May it please the commission, I will not plow the ground that's been covered eloquently by Mr. Zakora and Mr. Caro, but simply say that I think that you're being asked to approve a non-unanimous settlement agreement that unfairly allocates the storm costs. I think you'll find that the evidence would support a different resolution of those costs and give you ground upon which to reject the non-unanimous settlement, simply because it appears from the evidence that all of the classes are subsidizing the residential class, when in fact the residential class usage went up by virtue of the fact that, for example, this is not unique to schools, but other businesses and schools were asked to conserve. They did conserve. The Wichita school system, USD 259, was closed for 5 days, the 13th through the 17th of February. They did use some power to maintain the integrity of their plumbing system so it wouldn't freeze, but there were no classes during that period of time, and we know the usage declined. We believe the allocation of the non-unanimous settlement agreement is unfair, and in part because it's based on projections in 22 and 23 as opposed to what really occurred. I'd ask you to reject that non-unanimous settlement agreement. Thank you.
Thank you, Tim. The final opening statement will be on behalf of the KCC staff. Charlie Massington, please.
Yes, good morning, commissioners. So out of respect for the commissioners and other parties' time today, I will not reiterate an extensive background to this docket, nor will I restate the analysis of the non-unanimous settlement agreement's reasonableness, as that can be found in the filed testimony in support of the settlement agreement filed by staff on April 29th, 2022. This docket is an investigation into the costs incurred by and the actions of Evergy Kansas Central, or EKC, Evergy and Evergy Kansas Metro, or EKM, and when I refer to them together, I will simply say Evergy. Their actions over the course of the devastating storm known as Winter Storm Uri that took place in February 2021. Staff's investigation into Evergy's actions during Uri included conducting substantial amounts of discovery, numerous meetings and other communications with various parties to the docket, and an in-depth analysis into both Evergy's handling of Uri and its plan to reduce the financial impact of the storm. The non-unanimous settlement agreement before you today is fully supported by staff, and the reasons for that can be detailed further when staff witness Justin Brady is on the stand. Most pertinent today for my opening is to counter several of the misunderstandings and misstated arguments that can be found in the filed written opposition to the non-unanimous settlement agreement and filed testimony by opposing parties, authored by NGTCC, KIC, and the Wichita Public Schools witness, Mike Gorman. So that as we begin the evidentiary portion of today's hearing, we do so all having the correct understanding of what exactly is and is not taking place under the supporting parties' settlement agreement. So I shall begin with the opposing parties' arguments regarding cost allocation. They argue the allocation is improper because it does not reasonably assign the extraordinary Uri costs to customers that caused EKC to incur these costs. And I think an important point to make right here and now is that the agreement does not call for the specific rate classes to pay a certain percentage allocation of these costs. It simply assesses the rate classes on the basis of all future kilowatt hours consumed for the years 2022 and 2023. It is a per kilowatt hour rate that applies to all customers. The agreement would allow all of the extraordinary Uri costs, which did create a revenue shortage on the EKC side, but resulted in excess revenue on the EKM side, to flow through the actual cost adjustment, or ACA, portion of Evergy's retail electric cost adjustment, or RECA surcharge for both EKC and EKM customers. The RECA itself does not contain any specific rate class cost allocation, meaning in order to use this mechanism, specific rate class cost allocation cannot occur. The absence of specific rate class allocations is because they are all being treated equally under the settlement. Staff believes allowing the URI costs and revenues to flow through the RICA is reasonable due mostly to the proportionality of these costs, looking at the incurred costs in light of Evergy's overall annual costs in fuel and purchased power, as well as the ultimate impact on customers compared to that of other winter weather investigations. For example, as detailed in EKC's most recent ACA filing in docket number 22-EKCE-447-ACA, Evergy witness Elizabeth A. Harrington testified that between January 2021 and December 2021, EKC incurred approximately $616 million in fuel expense and purchase power costs. And with permission, I will share the relevant portion of her testimony now on my screen for reference.
Yes, please, if we can do the share screen.
Okay, thank you. Here we go. Can everybody see that okay?
It's up now.
All right, wonderful. So this figure does take into account, the 616 million figure does take into account the URI costs, which amounted to roughly 119 million. So if you deduct the URI costs from the overall fuel expense and purchase power costs, you're left with roughly 500 million. So putting that into perspective, the URI costs of 119 million are less than 25% of the total of 1 year's worth of fuel and purchase power costs. I will scroll down as well to include some of that additional information regarding the 119 million related to URI. And as the commission will recall, several of the other Winter Storm URI financial plans have involved fuel expenses that amounted to multiple years worth of expenses during this one event. And with this, staff is not attempting to minimize the impact of Winter Storm URI on Evergy. Of course, incurring 25% of your yearly but annual fuel purchase power costs over the course of 2 weeks is nothing to minimize. However, we are trying to put this in perspective with the overall annual cost that Evergy pays already for fuel purchase power, as well as its impact to Evergy as compared to the impact of costs incurred on other utilities that we have dealt with already in these winter weather events. And further, all parties to this docket, including the opposing parties, recently just signed off on an agreement in docket number 22-447 to allow an incremental 116.9 million of non-URI under recovery from 2021 to flow through the ACA portion of the RICA, effective April 1st of this year, 2022. That amount of 116.9 million is not materially different than Evergy's Winter Storm URI costs. And there's an added layer in Evergy's URI docket in that on the Metro side, customers will be receiving a refund because EKM sales into the market actually exceeded the costs incurred during URI. This is another part of staff's reasoning for supporting allowing these costs / refunds to flow through the RICA. The RICA mechanism is meant to be used for under or over recovery true-ups, and we are dealing with both in Evergy's case. Given the relative materiality of both the under and over recoveries, staff believes it is reasonable and the most efficient method to allow both to flow through each counterpart's separate ACA. What seems to be fueling the opposing party's position is the idea that because some of these entities are interruptible, they should receive extra compensation for their conservation efforts. I would like to point out that large industrial interruptible customers already receive many benefits, some being on special contracts, and even for others who are not, agreeing to be an interruptible customer comes with monetary benefits. They are already compensated for the ability to be interrupted, and being interrupted is what is called for in the contracts in which they have agreed to take part. I'd also like to explore the concept that the opposing parties have put forth that because they conserved They deserve monetary benefit, and even the implication they have raised that somehow this commission and Governor Kelly promised them such at the outset of the event. First, there is nothing in the existing tariffs for industrial or residential customers that states that during times of constraint on the system, anyone who conserves energy will receive some additional monetary compensation or additional deduction from the overall cost. While there were general statements that conserving energy would result in lower costs overall, it was never contemplated, and more importantly, there was never notice given to any customer class that conserving would directly result in any monetary benefit other than overall lower costs. Those customers who conserved of any class would have in fact received lower bills in March of 2021, extraordinary costs notwithstanding, than they would have had they not conserved. And this is simply how the system works. If I conserve energy more than usual during a particular month, I am rewarded by a lower electric bill. So the conserving customers would have already seen some individual benefit based on lower usage in the month of March of 2021, in addition to the overall lower extraordinary costs that we see here. And customers that conserved during February 2021 reduced the overall costs that Evergy incurred, which necessarily results in a lower overall per kilowatt hour charge to all customers, regardless of which customer class they are in, as called for in the settlement. The settlement spreads the benefits of conservation efforts made by all customers during February 2021 to all Evergy customers equally. No one is being penalized. Second, it is staff's point of view that overall, the relative materiality of the impact that Uri had on Evergy Central is due in part to such conservation efforts across all classes. Conserving energy during this time did keep these costs to a relatively small amount as compared to other utilities which weather dockets. The reward for that conservation is lower costs overall. It is not some form of special treatment as the opposing parties seem to argue. Third, the implication in the opposing parties' filed statement that Governor Kelly and the commissioners somehow guaranteed or promised benefit outside of generally lower costs is simply untrue. The calls for conservation were across the board to reduce the overall impact on the system and the overall cost of the event, and were nothing more specific than that. Commissioners, I am certain that each of you, as well as myself, and likely every other participant to this docket, did what we could to conserve our energy usage during Storm Uri. Our efforts contributed to the reduction as a whole of costs. This behavior was not purely motivated by an expectation that we would receive some monetary benefit for doing so, other than reduced March 2021 bills and reduced overall costs, but rather it was motivated by the calls from the commission and the governor to do your part for system reliability and band together as a state to withstand the event. It benefited everyone to conserve immediately during the event because it aided in keeping the system up and running as a whole for all to use. Now, we cannot control what our neighbor does. While I may have chosen to conserve, my neighbor might have had their heat blasting during the event. Similarly, there is no indication that all large customers conserved equally or at all. There is nothing in the tariff that would have notified Evergy customers of any class that if they didn't conserve, they would be penalized by higher individual costs, and those who conserved would receive lower individualized costs. And what the opposing parties are asking for is a specific cost allocation based on just 5 days of February 2021. Staff is unclear as to why the opposing parties think February 12th through the 16th of 2021 is the most appropriate time frame on which to base this cost allocation, particularly given that we know February 17th was the highest gas price day of the event, and that elevated natural gas and wholesale power market prices were experienced for a much longer period in February 2021 than just 5 days. The chosen dates of the opposing parties, the February 12th through the 16th, are unduly narrow and do not fully encompass the extraordinary costs incurred during the event. Allocating costs in the manner suggested by the opposing parties is not contemplated in the tariffs and would arguably result in imposing a retroactive time of use rate for the days they have identified, and days that they have identified notably over a year after the fact, without having given prior notice to customers that this is how they would be billed. Also, in pre-filed testimony, the opposing parties referred to the commission's approval of Southern Pioneer's financial plan to support their argument. Staff would counter that there are several important distinctions between Southern Pioneer and Evergy, and staff witness Justin Grady is prepared to discuss those with the commission and the parties during the hearing today. One major benefit and point of having individualized dockets for each utility during URI is to be able to tailor those proceedings and the ultimate approved financial plan to each company, as each has different mechanisms and considerations at play. Simply because it made sense for Southern Pioneer to allocate its costs in a certain way does not at all mean it makes sense to require Evergy to do the same. Further, what the opposing parties are requesting to be implemented for Evergy is not the same as what was approved for Southern Pioneer. As to the settlement before you today, staff fully supports this plan as a reasonable resolution of the issues, and simply put, it's a good deal for customers. Evergy has agreed to implement only a 1% carrying charge up until the point at which these costs begin to be recovered, and at that time, the carrying charge will drop off. The current estimate is that an average EKC residential customer will be charged about $2.82 per month for 2 years. This represents the lowest carrying charge and the most affordable customer impact to be established for Winter Storm Uri costs yet. While each utility's circumstances were certainly unique, given the size of Evergy's customer base and given its footprint in the state, this is a favorable result for its customers. That and the efficiency of utilizing the RECA mechanism to flow through costs, in addition to the plethora of reasons for our support contained in witness Grady's testimony, is why staff is a proponent of this settlement agreement and why we would request the commission approve it in full. In the final analysis, the rates that are established in this proceeding are a matter of commission discretion and policy. Thank you.
Thank you, Carly. This does in fact conclude the opening statements. I might turn to our court reporter, Robin. We've been going for an hour and a half now. Would it be helpful if we took maybe a 15-minute break?
Whatever the pleasure of the commission is fine with me.
Okay.
If it's easier to take it now instead of between witnesses, it's fine.
That's one of my thinking is when we commence the examination of witnesses, it will provide maybe for better continuity. I believe that's what we'll do. We're going to recess for 15 minutes at this time. It's approximately 10:30. We'll resume at 10:45. We're off the record.
Let's see. That work.
All right, Michelle, if you're there.
Pam, are you ready to start back?
Robin, are you good to go?
I am. Just let me get the video going here so I can see everybody.
Okay. Michelle, when you put the full screen up, I'm going to be good to go then.
All right, dropping now.
All right, it's 10:45. We're back on the record. We're now going to turn to the examination of witnesses, and we'll begin first with the Evergy witness. Ms. Dingus, would you please call your witness?
Yes, thank you, Chairman. Before I call Mr. Ives, I would like to offer the direct testimony of Ron Clote into the record. It was 18 pages along with 5 exhibits of direct testimony. And my understanding is that none of the parties and none of the commissioners have questions for Mr. Clote today. So I would move for admission of that testimony.
Is there any objection? Without objection, that testimony is admitted.
Thank you. And Evergy calls Darren Ives.
Mr. Ives,
May I offer?
can you hear me okay?
I can.
I'm going to ask you to raise your right hand, please. You do solemnly swear the testimony you are about to give in the case now in hearing will be the truth, whole truth, and nothing but the truth, so help you God.
I do.
Thank you.
May I make a point of inquiry, Jim Zakora? Are we going to take up the judicial notice issue now, or is Ms. Dingus going to offer that at a later point?
Mr.
Well,
Zakora,
I'm going to let, please
Chairman.
go ahead, Ken.
I was planning on offering 3 of the items at the end of Mr. Ives' examination, and then 2 of the items during the cross-examination of Mr. Gorman.
I think it would be a wise use of, in my opinion, a wise use of judicial economy to hear the challenge on the notice of the motion to take judicial notice prior to the beginning of the examination.
Happy to do that. I had intended to offer those during Mr. Gorman's examination because I think that the relevance of the items will become more clear after I have a chance to ask some questions. But if the commissioners would rather address it now, that's acceptable as well.
My inclination is to defer to your wishes, Ms. Dingus, still allowing for the opportunity to object.
Thank you.
Please continue.
Mr. Ives, can you please state your name and business address?
Yes, my name is Darren Ives and my business address is 1200 Main, Kansas City, Missouri.
And did you cause to be filed in this docket 16 pages of direct testimony and 20 pages of testimony in support of the settlement agreement together with 3 exhibits?
Yes, I did.
Do you have any corrections to that testimony today?
None that I'm aware of at this point.
And if I ask you the same questions today under oath, would your answers be the same?
Yes, they would.
I move for admission of the direct testimony and testimony in support of the settlement agreement of Darren Ives, along with the 3 exhibits, and tender the witness for cross-examination.
Very well. Is there any objection to the admission of the testimony? Without objection, it's admitted. And we will turn indeed to cross-examination. We'll turn first to Mr. Zakura on behalf of NG, TCC, and KIC.
Thank you very much. Good morning, Mr. Ives. Nice to see you again, sir.
Good morning, Mr. Zakura. Same.
I would like to start out, please, if I could, just clearing up some parts of the record. Could you please, Mr. Ives, state the total amount of additional costs at this point of time that Evergy Kansas Central has?
I'm flipping to the exhibit DRI2 to my testimony in support, Mr. Zakura. Total fuel and non-fuel costs that Kansas Central has related to the URI event presented on that page at $119,693,342.
Thank you. I would further ask you to define what you mean by fuel and non-fuel. What is the difference in those costs?
Sure. So for the fuel cost, they are a combination of the fuel that was incurred to support our generation during the event, the purchases that were made in the market for electricity during the event, or the purchase power, as it's often referred to, and then netted with the benefits of any off-system sales revenues that we receive from selling power into the market to parties other than our retail customers during that same time frame. And then for the non-fuel charges, part of the commission's order establishing the ability for this deferral recognized that incremental costs incurred during the URI event, in this case, costs for incurred to pay some contractors during the event, some overtime labor, and some damage maintenance costs that were incurred during the event make up that amount of non-fuel costs that are being considered.
Where in the fuel and non-fuel costs, Mr. Ives, does natural gas and coal reside? Is that a fuel cost?
Yes, sir. Fuel costs.
As I understand your testimony, and please correct me if this is not a correct understanding, the additional winter URI costs that Evergy Kansas Central is claiming herein is for the period of February 12 through February 16, 2021. Would that be a correct statement?
No, that's not correct. The way the costs were calculated for the winter URI event were by comparing the costs that Evergy incurred in February of 2021 to the 3-year average of cost that were incurred in February for the years 18, 19, and 20. So it is the month of February, basically the costs that were above the 3-year average of those preceding 3 years.
Thank you for that clarification. What does the February 12 to 16 time period represent in the testimony and the discovery?
I don't think anything from my testimony or our testimony specifically addresses the period February 12th through 16th. I believe your witness may use those dates in formulating his testimony.
Let me further ask a question, if I could, Mr. Ives. Were the preponderance of the 119 million of costs incurred during the period of February 12 through February 19?
I don't have the breakdown of cost specific to the days, but again, the costs that we're talking about in the 119 million reflect the totality of costs incurred during the month of February 2021 as compared to the 3-year average. So certainly there were costs incurred during the 12th to the 16th. I think as staff's attorney mentioned in her opening statement, the highest price gas day surrounding the event may have actually been on the 17th of February in the SPP region, and there certainly were a number of days in the month that had high cost as a result of the extreme weather event.
Let me break it down a couple of different ways, if I could, Mr. Ives. Could you tell me what the cost of purchase power on SPP was during the period of February 12 through February 16?
I don't believe I have that information in front of me in my testimony.
Would it be your opinion, Mr. Ives, that those prices were elevated during that period?
It's my opinion that the purchase power and gas prices were elevated through much of February of 2021, and candidly, natural gas and power prices continue to be elevated in the current market environment.
Let me ask it a little different way, and I don't mean to keep asking the same question, but in the period of February 13, 14, 15, and 16, natural gas prices were $329.59 on the Southern Star Gas Daily Index price. Was Evergy buying natural gas during that period at or about those rates to generate electricity?
Chairman, I'm going to object to that question. I'm not sure where those numbers are coming from. Mr. Ives has already said he's not familiar with the prices on each specific day, so I don't know that he can answer that question.
Do you rephrase the question?
Mr. Ives, do you have knowledge as to what the prices that Evergy paid for natural gas in the period February 12 through February 16?
Mr. Zakura, I mean, all I can tell you is that during the time frame of the winter weather event and for a number of days thereafter, there were elevated natural gas prices and purchase power prices that Evergy paid in the market at that time. As to specific prices for specific days or hours of a specific day, they would have varied widely over a number of days, but certainly they were elevated as a result of supply constraints and demand pressures during the winter weather event.
If you know, were the purchase power prices during that period in excess of $1,000 per MMBTU? Excuse me, megawatt hour?
I know that at certain times during the winter weather event, that they were in excess of $1,000. And I know that there are, certainly some SPP reports that are probably part of the information in this docket and press releases that would indicate as such.
May I, Mr. Ives, turn your attention to the proposed or the non-unanimous settlement agreement, and it's paragraph 34.
I am there.
Okay. Would you read for the record staff number 15, which is labeled as IV on page 13?
Yes, at the top of page 13 of the agreement. It's rather long, but it says staff number 15, for future severe market pricing events, Evergy should send consumers a comparative price signal when the average day ahead DA wholesale energy price exceeds the SPP Southwest Power Pool IM integrated marketplace soft cap of 1,000 per MWH or megawatt hour for a single operating day. The price signal should be updated daily and include recent wholesale energy pricing before the market event. The price signal should provide consumers a basic background of the market event and pricing information to make decisions on their energy usage. Evergy should convey this information alongside Evergy's public appeals for energy conservation.
Let me ask you a couple of questions about that, if I could, Mr. Ives. Does that indicate to you that during this period of February, that prices on SPP exceeded $1,000 a megawatt hour?
Well, I think there are two different questions, Mr. Zakura. What that indicates to me is that it was a staff recommendation of a potential operating parameter to evaluate prospectively. I don't think it says anything necessarily on prices for the event itself. That said, I don't dispute that there were times during the winter weather GIE event in February of 2021 where prices per megawatt hour in the SPP market were in excess of $1,000.
May I ask a follow-up question, Mr. Ives? Can you state how much in excess of $1,000 per megawatt hour?
I do not have a full range of prices during that February event in front of me to the best of my knowledge.
Let me direct your attention. Let me go ahead and get these in the record, Mr. Ives. If I could please ask you to have before you what is KIC number 13. KIC number 14, KIC number 15, KIC number 16, KIC number 17, KIC 18, KIC 19, KIC 20, KIC 21, and KIC 22. Do you have those before you, Mr. Ives?
I have them in front of me, yes.
May I first turn to KIC number 13? Do you have that before you?
I do have it in front of me.
And does that accurately represent a filing made by Evergy at the Federal Energy Regulatory Commission with regard to 20 largest purchasers from the electric utility operating companies? I'm reading from the reference line on the first page of KIC 13.
Yes, I believe it accurately reflects that filing. I did not go back and look at the filing to make sure this was a full and complete copy of it, but it appears to be as you state.
I would move for admission of KIC 13.
Is there any objection? Without objection, it's admitted.
Now, KIC 13 basically lists the largest 20 customers on Evergy, Kansas Central, the North or West Star Group, and also the South, which is the old KGE group. Is that correct, Mr. Ives?
I'm sorry, I was flipping pages. Can you restate that question?
Certainly. If you would please turn to page 2 of KIC 13. If I may ask you, does that accurately reflect the 20 largest customers on Evergy Kansas Central Inc., which would be the North Division?
Yeah, I suspect it does. That's what the filing indicates that it is.
Okay. And that would include not only private businesses, but also public businesses as well, correct?
Correct.
Including, would it be correct, the city of Topeka, Johnson County, Kansas State University, the University of Kansas, is that correct also?
Yes, sir, they are on the list.
And those companies would pay their part, whether it's the allocation that our group provides or the RECA that you're suggesting, they would all be paying part of that $119 million. Is that correct?
Yeah. All customers of Evergy Kansas Central will be paying a portion of that based on the allocation that's selected by the commission.
May I ask you to turn to, let me count the pages here for you. The 5th page, please, of KIC 13.
You said 5th page, correct?
Yes, sir. And it's denominated at the top, sir, as Evergy Kansas South Inc.
I'm there.
Okay. And again, like the list that we just went over, these are the lists. This is a list of the 20 largest customers of the South Division, which was formerly KG&E. Is that correct?
Yes, that's what the filing purports to represent for calendar year 2021.
And if you look at this, it would also include, in addition to private companies, the city of Wichita, USD 259, Wichita State University, correct?
Yes, sir, they are on the list.
Now, and they also would be paying either the allocable share or the share that goes through the RECA. Is that also correct, Mr. Ives?
Yes, as I mentioned, all customers will be paying a share of the incurred costs for the event.
May I please ask you, sir, to turn to KIC 14?
I'm there.
Okay. And may I please ask you, this is only 2 pages, but there is a file stamp on the first page. Is this a monthly compliance filing made by Evergy at the Kansas Corporation Commission?
It is, as you may have indicated, an excerpt of a monthly compliance filing. So it's 2 pages of a broader monthly compliance filing that is made.
And if I could please ask you, sir, to turn to page 2. And on page 2, that gives us if I'm reading this correctly, it gives us a number of customers in each of those categories of residential, commercial, and industrial. Do you see that, sir?
I do see that on, it's actually page 1 of exhibit 1 of the filing. It's page 2 in your exhibit, not page 2 of the total filing that would have been made.
Thank you for that correction. And if we go to March of 2022, Mr. Ives, that would indicate that there's 87,658 commercial customers.
I'm straining to read it, but yes, that's what it appears to be.
And also it indicates that there's 4,458 industrial customers, correct?
Yes, sir, for Kansas Central for March of 2022.
I would move at this time that KIC 14 be admitted to the record.
Is there any objection? Without objection, it's admitted.
Mr. Ives, I have one more kind of general framework question to ask you. Would you turn to, please, KIC 15?
I am there.
And KIC 15, would you please agree, if you can, that KIC 15 is an index of electric communities that are served by Evergy at Kansas Central?
The first 3 pages of that appear to be reflective of those communities for the north, and the 4th page appears to cover the entities in Evergy, Kansas South for the areas.
I would move at this time for admission of KIC 15 into the record.
Is there any objection?
No objection.
Without objection, it's admitted.
Now, Mr. Ives, if I could, what I'm trying to do or trying to establish with KIC 13, 14, and 15 is the fact that whether it's the allocable assignment of costs as proposed in Mr. Gorman's testimony, or that recovery mechanism contained in the non-unanimous settlement agreement, that will impact all of these communities throughout the state. Is that correct?
Yes, Mr. Zakura, I think we're here discussing the appropriate timing and allocation of recovery of the costs that were incurred to serve customers in all of Kansas Central. And I think it will impact certainly all of our customers as the event did.
May I please, Mr. Ives, ask you to turn to KIC 16.
I'm there.
And would you please identify this exhibit by the title at the top?
This exhibit appears to be a release from Evergy, and the title is Evergy Asks Customers to Conserve Electricity.
And if I could draw your attention, sir, to the first paragraph of that release, would you agree that the document indicates that the request to conserve electricity is from the Southwest Power Pool?
I would agree that the first sentence in that release says, at the request of the Southwest Power Pool, we are asking customers to conserve electricity. We, Evergy, asking customers to conserve electricity. It is a part of the process with SPP during their emergency alerts.
And would you agree that that request, if you go to the third line, is from February 14 through February 17?
Yeah, this I would agree that this release is dated the 14th and that request the conservation in this release through the 17th, correct?
Now, if I could, well, let me ask one question before I go to the last part of the paragraph. To your knowledge, did Evergy make a request for conservation to the public other than at the request of SPP?
Yes, I believe we made a number of requests through a number of media outlets and sources and press releases and meetings. We certainly also had direct dialogue with the commission and direct dialogue with the governor's office, and appreciated their appeals as well. There were a number of appeals made during winter weather event Uri.
Let me direct your attention to the last sentence, Mr. Ives, of KIC 16.
Okay.
And doesn't that indicate that on the 14th, there was potential for electricity shortages, and that SPP has asked all utilities in the region to encourage customers to reduce electricity usage in order to maintain electricity supply overall and avoid potential power outages?
That summarizes what that sentence says, yes.
Now, there were rolling blackouts during some period of February. Would you state for the record when those occurred?
I believe they were on the 15th and 16th. Yes, looks like the mornings of the 15th and 16th for a period of time as directed by the Southwest Power Pool.
Let me ask you, Mr. Ives, since you indicated that SPP requested Evergy to make an appeal for conservation, I believe you also indicated that you were in rather constant communication with the governor's office and the commission with regard to conservation. Would it be your testimony that conservation during the period of, let's just say, February 12 through February 17 was an important element of your response, Evergy's response to the energy crisis?
It'd be my testimony that it was an important element of Kansas's response to the crisis in the winter weather event, and was undertaken by all customers that had the ability to do so, kind of regardless of class. But yes, it was very important to Kansas and to the overall ability to maintain power and reliability. Mr. Nickel summarized it well in his opening.
I would move that KIC 16 be admitted to the record.
Is there any objection? Without objection, it's admitted.
Now, Mr. Ives, I would ask you to please place before you KIC 17, 18, 19, 20, 21, and 22.
I have them.
Thank you. And if you recall, were these documents 17 through 22 part of your testimony in the Missouri Public Service Commission with regard to Winter Uri?
I do not recall whether or not each and every one of these were. I know I had a number of SPP communications and SPP reports that were a part of my testimony in the docket in Missouri, so I would not be surprised by that.
Well, I would just say I did my best to get them all, Mr. Ives. But let me at this point move for admittance of KIC 17, 18, 19, 20, 21, and 22 to the record.
Is there any objection? Without objection, the 6 exhibits 17 through 22 are admitted.
Mr. Ives, let me please direct your attention to KIC 17, sir.
I have it.
To your knowledge, sir, is this the first request of SPP to? Is this the first request of SPP as to tightening energy conditions on the integrated system? May I withdraw that question? Let me direct your attention, Mr. Ives, to the second paragraph of KIC 17.
I see it.
And does that indicate that on February 9, SPP had declared a period of conservative operations?
It does.
And what does a period of conservative operations entail?
Yeah, it is a signal. I mean, if you read the third paragraph in KI 17, it talks a little bit about it in terms of signaling to the utility operators that they should operate conservatively to mitigate risk. So it is a stage in communications from SPP in an effort to continue to balance the operations of the grid and maintain reliability and service to customers across the Southwest Power Pool footprint.
And as a part of the conservative operations, and in the same paragraph, it lists energy emergency alert level 1. Are part of the responses to those conservative operations appeals for conservation?
Yeah, there are different stages, certainly, of communication from SPP. As you note, starting with a period of conservative operations, you'll notice that they did not move to an energy emergency alert level 1. until the 14th, so a number of days later. And there are, appeals at various stages of the process that can call for conservation.
Let me, Mr. Ives, direct your attention to KIC 20, please.
I'm there.
Would you please take a look at the second paragraph on KIC 20?
I see it.
And this KIC 20 is dated February 15th, is that correct?
That's correct.
And it indicates that the SPP system reached a peak of 43,661 megawatts on February 15th. Is that correct?
That's correct.
Now, let me direct your attention to the last 2 or 3 lines of that paragraph. It says, SPP fell about 641 megawatts short of demand for the period beginning just after noon. Do you see that?
Yes, I do.
And what was the result of their failing to meet the demand by 641 megawatts? What was the result on Evergy?
Yeah, so not just on Evergy, but on all load serving entities in the SPP footprint. SPP declared an energy emergency alert 3, which required load shed of load to balance out the system for that falling short of demand. So we all had to begin to involuntarily curtail customers during that window of time.
And when you say involuntarily curtail customers, what do you mean by that, sir?
Yeah, we had to institute rolling outages across our service territory in proportion to our entity's load share of SPP in order to balance out the system for that shortfall of demand that's referenced in this response.
Now, on February 15, or the day or two before and the day or two after, let's just say that period, do you believe that Evergy customers, at least part of them, were engaged in conservation?
I believe a significant number of our customers across all of our classes were making best efforts to heed our request in the commissions and the governor's request for conservation. Yes, at least based on our dialogue with customers across classes and anecdotal personal knowledge, including at that time I was testifying in the Capitol in Topeka, speaking with legislators about the event, and certainly heard the perspective of their constituents' efforts.
Would it be fair to say that the number of shortfall of 641 megawatts would be greater, and perhaps materially greater, if conservation efforts had not been ongoing?
Yeah, absolutely. I think if all of our customers had not made efforts in whatever form they did, we could have had a more significant shortfall, which could have required longer outages or more outages during the window when SPP called for them. That is certainly a reasonable possibility.
Let me step back from this and look at a more general kind of area of questions for you, Mr. Ives. When did Evergy begin making appeals for conservation?
I'm trying to determine, Mr. Zakura, if I have that in my direct testimony in this docket. I do know on page 4 of my direct testimony to this docket, there's a pretty good table that summarizes a number of the things that you've been asking about in terms of SPP status and the timing of some of the rolling outage events and things like that. But the table starts really in the early stage of February. So I know there was a number of days in early February where we began to see weather reports and began to take operational actions to put ourselves in the best position for the event. I know we started communicating with SPP on self-committing fossil fuel resources as early as the 6th, I think, of February. I'm just not sure, Mr. Zakura, that I have on the top of my mind or in my testimony the first date that conservation requests were made by Evergy, either through press release or social media or other avenue. It would have been in the early part of that event.
Let me ask you about operating protocols of Evergy. Does Evergy reach out to the larger customers when there needs to be conservation or a reduction in load?
We do, Mr. Zakura. We have some customers that actually have some contracts that require curtailment, and we certainly reach out to those. I think we've answered a number of discovery requests in this docket that indicated, that there were a number of other customers that we reached out to discuss whether or not they could voluntarily curtail or conserve to benefit operations during the event.
Isn't it the case, Mr. Ives, as a practical matter, you reach out to the larger customers or the group that uses the most power, because that would give you the most relief if they step off the system or step down from the system? You get more reaction or more reduction from a larger group of customers than you would from a smaller.
Well, I would say it's more than just that, Mr. Zakura. I would say it's also the availability of outreach. We have specific relationships and specific employees that have relationships with large customers and contacts at those that can make that outreach. We have in Kansas Central roughly 700,000 residential customers, plus or minus. We certainly can't outreach to each one of them individually. That's why we use press releases and social media platforms and broader communication strategies to touch those customers. So it's a little bit about the relationship and a little bit about our normal interactions with large customers as compared to individual residential customers. But yes, certainly large customers, if they are able to voluntarily curtail operations, can add larger amounts of conservation than an individual residential customer can.
And just to follow up on that, Mr. Ives, isn't it the case that for most of the larger customers, certainly all the ones that we talked about, the 20 larger customers, there'll be a key account representative of Evergy that has a relationship with each of those?
I did not use the word key account representative, but that is what I meant by the individual contact. Yes, sir.
And in fact, all of those were individually called it would be true that, to your knowledge, all of the larger customers were individually contacted to conserve energy.
I would suggest that's true. I'd hesitate to say all because I didn't make the calls, but certainly we used our key account contacts to reach out to all that we could. And we also reached out to a number of customers beyond the top 20 that were in that listing we referred to.
May I, Mr. Ives, direct your attention to KIC 21, please?
I am there.
Would you please describe what an EEA3 declaration is from SPP?
Yeah, I'm sure there are much more official terms than I will probably articulate, but it is the highest level of emergency alert that SPP will put out. In fact, the winter weather URI event is the only time that SPP has put out an emergency event 3. It is the last resort, as the article mentions, to preserve the reliability of the electric system. And this is the one that required the load shed across the SPP footprint or the rolling outages in order to maintain the integrity of the system and the reliability of the system when demand was outpacing the supply of electricity.
Now, on KIC 21, the term is used, controlled interruptions. Is that what you mean when you say rolling blackouts?
Yeah. I'm not sure I said rolling blackouts. I said rolling outages, but it is the term that I mean. It is an effort by the Southwest Power Pool to have us control reductions of demand on the system by shedding load during an event like that, so that you don't have an uncontrolled failure of the system, which could be much more catastrophic to reliability and, in extreme weather events like Uri, safety of our customers.
Let me go to finish up these exhibits if I could. KIC 23, please, Mr. Ives.
I am there.
Okay. And have you had a chance to review this prior to today, sir?
You did circulate it, so I have had a chance to glance at it, yes.
And I believe I sent it on Friday. And would you look at the first page of KIC 23?
I'm there.
And that is an attempt by me to indicate the percentage of residential of the entire megawatt hours on an annualized basis for residential users. Do you see that?
I do see that.
And you're certainly an expert in regulation and you're an expert in these types of items. Would you agree that on an annualized basis, looking at the period 2018 to 2021, that the total volumetric usage on the Evergy Kansas Central system for residential users is 33 or 34%?
That is the range that it is operated during the 4 years that are depicted in KIC 23 on an annualized basis.
I would move that KIC 23 be admitted.
Is there any objection?
No objection.
Without objection. Thank you. Without objection, it's admitted.
Mr. Ives, I would like to generally talk to you about cost recovery if I could for a little bit. It won't be lengthy, but cost recovery if I could. As I indicate, well, first let me say, how many years have you spent in utility regulation?
I have been in the specifically in the regulated area for about almost 15 years now. I've been in the utility generally about 26 years now.
And you would be familiar with concepts such as cost of service, is that correct?
I am generally familiar with those, yes.
I thought that you would be, sir. And when we talk about cost of service, would it be accurate to say that what cost of service attempts to do is to properly align and assign the costs of a utility company to those various classes of customers who use those costs and benefit from those costs?
That is generally right. I don't want to lead your questioning, but I would say there are differences when you get into the use of mechanisms like riders and other forms than just traditional rate regulation. But yes.
Well, I'm sorry, I didn't mean to interrupt you. And I didn't mean to say blackouts when you said outages, so I want to correct the record on that part as well. Excluding riders, would it be appropriate to say that, or would it be consistent with good regulation to say that there should be an effort made to assign costs to those, assign the costs and payment to those who create the costs or enjoy the benefits of the costs?
I'll generally agree with your comment, Mr. Zakura. I would say that as you are developing rates and recovery of rates, there are allocations that occur, and there are groupings that occur of like cost and like customers in order to affect rate regulation in the state of Kansas. So it does not always work specifically to an individual customer that they pay exactly what they incur, but your concept is certainly a fundamental concept of rate regulation in the state, yes.
And if you look at our position in this case, KIC or the coalition, you understand that KIC and the coalition have no position, and we're not challenging the total amount of additional cost of Evergy. Do you understand that to be our position?
I do understand that is the position you've asserted, yes.
And so we're really, at least from our point of view, we're strictly looking at what is the right allocation among the various customer groups to recover the costs that were incurred by Evergy. Would you agree with that as well?
I agree that is your stated position. I think your approach maybe oversimplifies the view of how costs were incurred during the winter weather event and how efforts were made to conserve. But I agree that you have stated that to be your position.
So we're simply talking about, at least from my point of view, getting the allocation and the assignment of costs as best we can to be consistent with the public interest and consistent with good utility practice and consistent with good utility regulation. Would you agree with that?
No, I can't. I can't stipulate to that. That sounds more like your testimony than mine.
Okay, let me break up the questions. Okay, see if we can. I'm not trying to do anything but see what we can agree on and not agree on. Okay, would you agree that we're asking the commission in this docket to decide the question of allocation based on the facts and good regulatory practice?
I believe that's what all of us are asking. We just happen to have differences of opinion, Jess.
Would you agree that with me that we're looking at the regulatory principles and not trying to favor one party or another, but trying to get it right according to cost assignment?
Well, again, I would say that's what all the parties are here for. We just have different positions on how to go about that.
And it would be correct, would it not, that Evergy is not meaning to put forward here any position that favors one customer classification or another?
I agree with that. I think Evergy has put forward a position that we think is consistent with how the costs were incurred and consistent with how they generally would be recovered under the fuel clause, and certainly not intending to favor one customer class over another. That we can agree on.
Can we agree that Mr. Gorman is attempting to present a position of his view of what the proper allocation would be?
I do hope that is how he put his testimony together, yes.
And you don't see anything in the testimony, do you, of Mr. Gorman, that would say that he is trying to favor one or another class? It's simply a different point of view. Is that correct?
Well, I might quibble just a little. I think it certainly does favor one class versus another, but it is clearly his point of view that he has put forward his support to advance in front of the commission.
Mr. Ives, thank you for bearing with me. That's all I have. Thank you.
Thank you, Mr. Zakura.
Yes, thank you, sir. All right, cross-examination, Coffeyville Resources.
I don't believe we have any questions. Thank you.
Thank you, Frank. Cross-examination, USD 259.
Thank you, Your Honor. Mr. Chairman, Mr. Ives, I really just have one question. Based on the proposed settlement agreement, or the settlement agreement that is being asked to be approved here today, of the total costs that is set forth in that agreement, do you have the dollar amount or percentage of the total that will be allocated under the settlement agreement to the class of schools?
One second, Mr. McKee. Mr. McKee, I would tell you a couple of things just to make sure that we're on the same page. Ms. Dingus brought this up in her opening statement, but the way the RECA tariff works for Evergy and the way that it's proposed to be used for the non-unanimous settlement agreement says that 2022 actual usage is what would be utilized to establish the rates for the charges that would would begin to flow back to customers for this in April of 2023. And then customers would incur those charges based upon their actual usage starting in April of 2023. So we could certainly make estimates of percentages based on history, but they may be different depending upon the school's utilization over the calendar year 2022 and through the recovery period as proposed in the non-unanimous, at least over the years of 23 and 24. But that said, I think if you looked at Mr. Gorman's testimony in this proceeding on page 9, he utilizes some confidential projected values to show a percentage of the cost that would be covered by the schools. And then he also shows for his position what that percentage would look like just utilizing the period of February 12th to 16th from a usage standpoint.
I understand that, but my question was, do you, on behalf of Evergy, have a dollar amount or a percentage amount of the total of the 119 million that you are proposing under the settlement agreement be allocated to the class of schools?
Well, again, we are proposing to use the tariff as it's designed, which will rely upon actual usage of the schools in 2022 and in the 23 and 24 recovery periods. So I don't have an exact value for you, but the information that is presented by Mr. Gorman is based upon data that was provided by Evergy, and I do not dispute the percentages that he calculated using Evergy's data.
All right, thank you. That's all I have.
Chair King, this is Jim Zakora, please. I neglected to say I have no more than 5 minutes of confidential exam for Mr. Ives, if I might have that opportunity at whenever the commission deems it appropriate.
Yes, let's go ahead and work through this public testimony first, and then we can turn to that. Let me turn next to the commission, see if there are any commissioner questions. I'll begin with Commissioner Duffy.
Thank you, Chair King. So if I could, Mr. Ives, on the outages, that the rolling outages. So how was that determination made when SPP sent the notification to the utility? How did Evergy go through, what process did they go through to determine the outages to meet the requirement that SPP had put forth?
Yeah, so good morning, Commissioner. Thanks. We have a plan in place that we are required to maintain and test periodically with the Southwest Power Pool to ensure that we can meet their needs if there were such an event to be called. So once we got notification from SPP of what our share of their system-wide load shed would be, we initiated that plan. Much of it is automated to begin to identify customers on circuits spread throughout our territory. We attempted to spread them out so that we don't put too much strain on one circuit or one section of the system, which could certainly have the unintended consequence to bring a longer term outage if we have too much variability in the system across circuits. So it's a fairly well defined plan, and one that certainly gets updated annually and tested annually.
So I'm assuming that you work to avoid hospitals and essential penitentiaries and prisons, that sort of thing. You work to avoid entities like that.
Yes, there are a number of critical use areas like that we attempt to exclude from that load shed plan. At that time, as you'll recall, we were also in the midst of dealing with COVID and the COVID vaccination process. So we were attempting to also exclude areas that would have been chilling and maintaining COVID vaccinations. So certainly it was all happening real time as we attempted to work through that, but we had a number of those that are built into that plan and tested annually.
So were industrial was impacted, large industrial, commercial?
Yes. Yeah, in general, it ran across all areas of our customer base and service territory, minus the critical infrastructure folks that we attempt to maintain service for obvious health and safety reasons.
And so when you say all areas, you mean residential as well?
Yes, ma'am.
And I believe Ms. Dingus said that her family, as well as our family, was impacted for, fortunately, it was only about 4 hours during that time. So you update that plan on a regular basis, is that correct?
That's correct, and we test it periodically with the Southwest Power Pool to stay in compliance with their procedures.
Okay. Let me switch to a different side. As you work with SPP to bring about the recommendations going forward, are you going to be reporting to them as well as to the commission on your progress? And what does that really look like? So, for example, some of the recommendations related to gas plants, weatherization, options related to the renewable energy. How exactly is that reporting going to occur?
Yeah, so that's a great question, and probably all still evolving, right? I mean, I think we'll be living this event for a long time, but as you are probably aware, I mean, we've had interest in this event from the commission here and staff and parties, the commission and staff and parties in Missouri, SPP, and a number of federal agencies all have had a number of recommendations and operating conditions to evaluate. Some of them are the same or substantially overlap across regulatory bodies. Some of them are different, but we are tracking them all and implementing them all, and we'll be reporting back to each agency that has had recommendations, our progress on those and our results from those. So I know that's kind of a vague answer, but it's a very broad swiping set of recommendations, and they're all being addressed and handled with with the agency or the party that has brought them forward to us.
Okay, so in particular, if we can talk about like taking units out for maintenance. So I'm sure SPPs, I mean, you have a concern, and it looks like because of one unit that was out at Jeffrey, that that was consequential in the scheme of things with hindsight, but pretty standard operation for you all to do your maintenance during the winter. So as you look to develop new schedules for maintenance, are you also coordinating at that higher SPP level so that as SPP looks across their footprint, I mean, that does that even matter? Or will you develop your schedule and that's what it is?
Yeah, no, it's a great question, and you're absolutely right. It does matter, and we will have that dialogue. And I think, you know, the particular unit at Jeffrey that you're speaking to, it certainly did end up being out during the URI event, which was not ideal by any stretch. I'm sure you're aware from the materials that it was out for some required environmental work that ultimately had a delay in ability for delivery of parts and execution of the work that took us into the window for the winter weather event. So what wasn't as, you know, obviously it's nothing as simple as just saying we made a bad choice in timing to voluntarily take something down. There were, you know, environmental requirements and a number of things in play. But to your point, we do look at our outage schedule. We coordinate across SPP to ensure that there aren't planned to be any unintended consequences on SPP itself. And then occasionally we have events that go above and beyond plan, either from a duration of an outage or from the type of weather event that certainly wasn't expected at the time we started an outage.
Okay. In the testimony, it talks about, for example, studying and looking at different types of weatherization, for example, for the wind turbines. Are you working with any of the labs in the United States as they are always working to improve, perfect, technology? So are you part of any study or program to evaluate weatherization and winterization solutions and how effective they are and cost effective?
Yeah, Commissioner, I'm not aware of any specific Evergy work with particular research labs on weatherization currently. That said, we certainly have received recommendations and feedback from regulatory bodies and agencies around weatherization and other activities. Certainly spending a lot of time working with our industry peers and our industry agencies to make sure that we're all advancing forward under, best possible outcome for sustaining against certain events. But to your specific question, I'm not aware that we have a direct dialogue with a lab on weatherization currently going on.
Okay, because ultimately, if you go beyond studying these solutions and look at actually coming to the commission and saying, we believe we should go forward with this or that, there will be a direct cost to your customers. So I'm hoping that you're using resources to short circuit that review and really come back in a timely fashion, whether you're visiting with, well, Minnesota, who deals with this all the time, or North Dakota, that you're part of a group. I would hope even it's a larger group. It's not just us, Evergy, but or Kansas, but looking to find the best possible solution, and so that we can understand what the cost would be and be able to weigh that going forward.
Yep, that's very fair. Thank you.
Finally, as it relates to low income assistance, that's mentioned as well, that you will be working with the parties for some sort of low income assistance rate or whatever. Do you have any more ideas beyond that?
You know, we have been talking for a fair amount of time, Commissioner, with David Nickel and the Citizens Utility Ratepayer Board about areas of interest in low income rates and support. What we've agreed to do is continue that dialogue and try and hone in on kind of the best path forward for Kansas. So we don't have anything developed yet, but certainly I expect Mr. Nickel and his team will have some ideas, and hopefully we can work forward to advance something that'll make sense for all of Kansas.
Okay. Thank you, Mr. Ives. I appreciate your time.
Yep. Thank you.
Mr. French.
Thank you. Good morning, Darren.
Good morning. How are you, Commissioner?
I'm well. And first of all, I just want to thank you and all the parties for simplifying this and narrowing it down to the easy issue of cost allocation. The issue is as simple as that. I know it's completely non-controversial. I've got a few, I'm going to call them regulatory geek questions, and I think you're well suited to help me answer those. And I think you'll be able to tell from these questions that I'm really struggling with this cost allocation issue. There's a lot in the Mr. Gorman's testimony that makes sense to me from a cost allocation perspective, but I've also been given pause by some other things I've heard, particularly in Evergy's opening statement. So want to run through a few things. And it's going to be a little all over the place. So hopefully we can just take each issue as they come. First, I want to address, this is a regulatory geek question, but it's also maybe a legal question. And so if you want to defer it to briefing, that's fine. But I heard your counsel in opening say that changing the cost allocation, as Mr. Gorman had proposed, I think she referred to it as an extreme form of single issue rate making. And I guess, I mean, I agree, it's single issue rate making, but my question is, isn't that exactly what we're doing right now? That we have bundled up sort of a discrete amount of extraordinary and unprecedented cost, and we are on a single issue basis trying to determine whether and how much of those costs should be recovered from customers, and what the right way is to recover those costs from customers. So I guess my question is, aren't we in the realm of where single issue rate making is actually appropriate and called for?
Yeah, we are. And, you know, I'm thinking back to her opening, and I think what Ms. Dingus was referring to in that single issue rate making discussion was Mr. Gorman's at least suggestion that the non-fuel, I'm going to use his term, non-fuel windfall from increased load of the residential class could be used to offset kind of the fuel impacts. And I think that's specifically what she was referring to. I don't think she was arguing that a different allocation methodology or approach would be considered single issue rate making beyond what the commission's order already established.
Okay, that is very helpful. I actually had another question specifically related to that, and this one probably is more appropriate for briefing, but maybe I'll just lay it out here. And it is, I agree. The commission's order authorizing regulatory accounting did not tell the utility to account for excess revenues associated with the weather during this time. But this may be a legal question, but perhaps you could give me your opinion. Would it be appropriate for us to consider that extra revenue the company received during that time in deciding how much of the extraordinary cost we will allow the company to recover from customers, if that makes sense?
Yeah, I understand your question, and I'll give you my opinion and thought. And I think when you talk about as Mr. Gorman does, non-fuel revenues in excess that would be built into rates, they're certainly out there, right? Because rates are set on weather normalized, kind of normalized loads across all classes. Mr. Gorman points out that there might have been some extra usage in the residential class during that window. He doesn't indicate how to handle any of the lower usage that he asserts occurred in the other classes that might have ended up lower than what was built into rates for customers. And maybe it's, from my opinion, maybe it's neither here nor there, right? Because I think you set rates based on normal, but you always have fluctuations, whether it's in the period of Winter Storm Uri, or whether it's during a 95-degree day on the 10th of May that maybe isn't normal by any stretch of the imagination. But when you look at total for 2021, and Ms. Dingus alluded to this in her opening, and you look at the earnings review and sharing plan that was submitted for Evergy Kansas Central, it clearly shows there in aggregate over the year wasn't a windfall of extra earnings at Central. So it might not be appropriate to pick this small window and treat it differently than the remainder of the year.
Okay. Well, not a question for you, but to the attorneys in the room, when you're doing briefing, I think it would be helpful to have that issue addressed, and to have it addressed of whether we even have evidence in the record to allow us to look at the total above normal revenues, not just of the residential class, but of the full system, and whether it would be appropriate or lawful to limit recovery using those revenues. So that's just a legal question. Let's move on. One more, I guess this is kind of a devil's advocate question. I know that Mr. Gorman in his testimony indicates that the residential class did not respond as much to lower its demand during the event. And in fact, their usage was probably up in response to the weather we were receiving. And I think I have heard the argument, or it's at least an argument I know, that perhaps it would be unfair to shift more cost onto that class because they had a limited ability to respond. They needed it to keep the lights on, to stay warm, to prevent loss of life. But I know I'm coming at this from kind of a regulatory geek perspective, not a populist perspective. But would that also be an indication that class really received the most benefit from the energy that was available during that time, that they really couldn't respond because they really needed it?
Yeah, it's an interesting question, Commissioner. I mean, I think the commission knows this well, that certain classes are more weather sensitive than others across the utility. No doubt about that. That's always been true. During that time, we also have to recall we were still in the throes of COVID. We had businesses that weren't operating at their full level, and people were at home or remotely working, and that makes a difference. That's not necessarily addressed or accounted for in this process. I think there are just a number of factors. I mean, interesting one, right? The schools. They talk about the schools making conscious decisions to shut down. It doesn't really show in Mr. Gorman's schedule that their URI versus non-URI usage really was impacted by that closure. But certainly all those people went home and they went to their residences when the schools made a decision to shut down and would have required the electricity to support them at home. So I think there are a number of factors. The other thing that we haven't talked about, Commissioner, we should, is, Mr. Gorman's argument makes it sound like the incremental cost of $119 million, it kind of applies to the incremental usage that happened during the event. That the prices were high from a fuel and a purchase power standpoint for every kilowatt hour that was served during that window. That's how the market works. It doesn't just pick those few extra residential kilowatt hours and price them higher. We were paying market prices for standard usage as well. And the way we did the numbers by comparing to a 3-year historical average tells me that there are costs in that $119 million, not just for higher usage, but also for normal usage that was just more costly during the event because of the market conditions.
Would it also be, I'm going to, I guess, make the counter argument of what I just made. I was trying to get more granular on which classes received which benefits, but I guess, would it be a fair counter argument to say, really, the entire purpose of the conservation that occurred was really to maintain the integrity of the whole system and to ensure that the whole system did not suffer a cascading collapse, which would have been catastrophic on every single customer class. And so maybe that's an argument that the cost should be more broadly spread. Is that a fair counter argument, or just a different perspective that may also be valid?
Well, if you think about where a lot of the conservation comes from, right? Mr. Zakura alluded to it in terms of SPP asking the utilities to initiate conservation communications. SPP is responsible for reliability of the system and maintaining the system integrity. So if you look at it from that light, then certainly that's a big reason why you would do that. And we talked about it earlier today, but those that had higher usage during the event, just like those that had lower usage for the event, have already had their bills impacted by the volumetric differences. Now we're just talking about the incremental cost that was incurred to maintain that system integrity and life and safety during the event.
Okay.
Is at least one way to look at it. Probably the way I would look at it.
Perspective. Okay, now one technical question I wanted to clear up for the record. There seemed to be a lot of crosstalk on the days that Mr. Gorman chose to create his allocation. I think he used the 12th through the 16th, and you indicated that those were not days you specifically cut out in your testimony or perhaps in any discovery. And I just wanted to clear up, are those the days for which Evergy accounted for extraordinary costs, or do you know where those came from? I'm going to ask Mr. Gorman in his. I'm trying to clear up what the basis of the 12th through the 16th is.
Yeah, so I can tell you what we did when we put together the extraordinary costs that make up the 119 million. We looked at all costs for fuel and purchase power that were incurred during the month of February of 2021 and compared that to the 3-year historical average for February, so 18, 19, and 20. And the difference between that 3-year average and what we actually incurred in 2021 is what we have deemed to be the extraordinary cost for Uri. That's how it's been reflected through the RECA to date. And that's how we gathered the cost. When Mr. Gorman, and I know you indicated you would ask him yourself, but when he put together his position, they appeared to have isolated much more narrowly than how we looked at the buildup of cost, probably more tailored towards the governor's announcements and the timing of things that were going on in that stage.
Okay, I will follow up with him. Looking back, he's probably the person I should ask that question to anyway, but I appreciate the context. Now, I guess I have some specific questions, and you'll have to forgive me. These may even relate to specific customers, but I'm going to be pretty careful to avoid confidential information. But I am interested. There were some generic statements in opening, but I want to understand with a little more granularity how different customers, important customers to the system, might be impacted if we were to follow the KIC approach. And so maybe just a little bit of foundation to start with. At an extremely high level, broad brushstrokes, I understand that the settlement position is to recover costs extraordinary costs over a 2-year period through the energy cost adjustment, which we'll often talk about as the ECA or the RECA. And my understanding is that KIC NGTCC coalition is proposing to instead recover extraordinary costs through a separate line item charge on all customer bills. And is any of that wrong?
That all lines up with my understanding. Yeah, it would take to do their proposal, it would take a separate line item charge on the bill to put that into effect. Yes. So
my further understanding is that certain customers today do not pay the ECA, that they have secured a separate supply of energy, and they pay sort of a stated charge instead of the ECA. And I'm just going to identify those customers because my understanding is those would be anybody signing up under your Renewables Direct program. And also it would be Spirit AeroSystems through their special contract. And that's all within the public filings. Is that correct?
That's correct.
Okay. So under the industrial's proposal, it would probably shift a large amount of extra cost onto any of the large volume users using that have secured separate supply under Renewables Direct, and it would shift a lot of extra cost onto Spirit AeroSystems. Is that correct?
That would be my understanding. Yeah, it's not really addressed in Mr. Gorman's testimony how you would handle those customer classes, but a separate charge by class generally seems to me it would have that effect.
Okay, I'm not making any point in particular here. I'm just trying to understand. It does seem to be a material consideration for us to understand how we would be affecting things. If there are large employers that thought they had secured a separate supply of energy and we are now shifting it onto them, that is at least something for us to consider in our calculation, I would think. Let me ask you about another special contract customer. I believe it's your only other, you only have two contract customers, correct? Spirit Aerosystems and Occidental Chemical.
We have one additional special contract customer.
Well, let me talk to you about Occidental because I'm familiar with their contract. And again, I'm only going to talk about public aspects here. I know several years ago, Occidental's contract was approved by the commission. And as I reviewed the order, one of the very major points of that contract was Occidental's participation in the Energy Efficiency Demand Response Program. And my understanding was that the value of that program was that during emergency system conditions, Evergy could call on them to reduce their demand by, I think, 80% within a very short period of time. I don't know if it was 15 minutes or something like that. And I know the staff gave that a lot of credence, and I believe in the commission's order approving the contract, they gave that a lot of credence. I think even the order even calls out that that's probably worth about $3 or $4 million a year to Occidental to compensate them for that. And I have not heard anywhere, and you can tell me if this is confidential or not, I don't know, but were you able to call on that during the event?
We did have dialogue with Occidental. They did not. They were not able to get to the levels that the contract calls for. They had concerns about their system and freezing up of their system. So they did make some efforts to curtail during some of the days, but certainly not near what that contract would have allowed for. And they also had, during part of that time, an outage. So they were down for part of the time, even more than what they were able to curtail because of the outage.
Okay. Well, sorry to hear that. I guess the other question I would have is, as I mentioned, that it does seem that they receive a large amount of compensation for the expected ability to reduce load during those times. If we were to approve the KIC proposal to further reduce the amount of cost going to those customer classes, I mean, would that be a double compensation since that customer and other customers, as you've indicated, are already receiving a lower rate to be interruptible?
That's a legitimate question. I mean, I think certainly there are a set of customers that receive rates based on interruptibility in the Central Service Territory, and to the extent they were not able to be interrupted at the levels that were contractually allowed for, that's probably a question the commission should consider in their assessment for sure. There are also, if the commission were to review that particular customer's contract, there are also some terms for charges that customer might pay if they do not meet their contracted interruptible levels that have not been billed at this point.
Well, that was going to be my question, is whether Evergy has requested that and whether that would be an offset to other customer costs.
Yeah, we have not enacted that phase of the contract at this stage, in large part because of the uniqueness of the event itself.
Yeah, that's helpful. Yeah, we recognize nobody, including myself, was operating at optimal conditions during a very specific week that February. Like I told you, I was going to jump around a lot. I think that addresses all of my questions. Let me just look through here really quickly. I don't see that I've written anything else down. Thank you, Mr. Ives.
Thank you, Commissioner.
Okay. Good afternoon, Darren. We are in
Good afternoon, Chairman.
I have one question I want to ask of you. If I take a look at holistically at the proposal that Mr. Gorman is suggesting, basically he's proposing a change in the allocation that would very generally result in some increases to residential. And he also proffers in mitigation of that increase some revisions to the amortization proposal. That is, by extending the amortization that is proposed in the non-unanimous agreement to be basically 2 years at 1%, he's suggesting that that be extended to 3. Is that your understanding? Is that a fair, broad overview of the proposal that he's making?
Yeah, that's very fair. And then as I talked with Commissioner French about, he is also, Mr. Gorman has also suggested that there might have been a windfall of non-fuel revenues from residentials that the commission could address.
Okay, so my question has to do with the amortization. If the amortization were to shift from the 2 years that's proposed in the settlement agreement, non-unanimous as it is, to the 3 years that Mr. Gorman is proposing, would the rate for that additional year still be at 1%?
Yeah, well, not addressed, correct?
In other words, let me rephrase that. Is that rate locked in?
Well, it would be my understanding that if the settlement agreement isn't adopted at the 2 years, that the rate, only applies to the settlement agreement as entered. I would tell the chair that interest rates are not where they were, not even a month or two ago, let alone back when these costs are incurred. If you look at our cost of capital today for commercial paper, it's many times what it was back at the time we incurred these costs. If you look at our long-term debt rates, it's much higher than it was back in 21 when we incurred these costs. So carrying for an additional length of time, it would be unlikely that Evergy would be excited about maintaining a 1% carrying charge rate.
Well, it was my concern about the general level of interest rates rising at this time, anyway, in the near term, that gave rise to that question. That's the only question I have. Another question or so that I had, Commissioner French had asked. I have one additional question to ask of you in the confidential session. I turn to you, Ms. Dingus. Any redirect?
Chairman, before we do redirect, I think it's appropriate if Mr. Zakora has confidential questions, rather than give them 2 bites at the apple. I think any confidential cross should come before redirect, but that just a suggestion.
Well, what I'm trying to do is segregate the confidential from the public here and try to handle them so that we don't go back and forth. So that was the reason I was proposing that we go ahead with the redirect with respect to the record we've developed so far in the public portion.
That's fine. It's obviously your prerogative. So,
Ms. Dingus, any redirect?
Excuse me, I do have some brief redirect. Thank you. Mr. Ives, you talked to Mr. Zakora about whether you were favoring one customer class over the other with the Evergy or with the method that will be used in the settlement agreement. Do you remember that conversation?
I do.
And is the effect of using the RICA for recovery the way that the settlement handles it, would the effect of that really be that we're treating all customers the same regardless of class, and they would all pay that same rate?
hold on one second. I'm getting some background noise here. Okay, can you hear me? Yeah, no, I agree, Ms. Dingus. Utilizing the methodology for recovery of over or under recovery of fuel and purchase power costs through the RICA, I mean, has the effect of treating all customers the same. And, I did mention in response to Commissioner French, I think that, customers that had higher usage during the event have already paid for their higher usage in the March following the event, and customers that had lower usage during the event have already benefited in their bills from having lower usage billed to them in March. So in some respects, that has been addressed, and what's left is I'll call it the traditional over or under recovery due to the market costs compared to what's in rates. It's just an extreme event market cost in the case of Uri.
And Mr. Ives, if the conservation efforts that various parties made resulted in lower costs overall, would that then be reflected in the KWH rate that will be billed under the RICA?
Yes, absolutely. Rather than 119 million without conservation, I'm sure we would have had much higher costs that we'd be talking about today. It's been discussed here that fortunately our costs were lower than many of our peers during the event. Hopefully some part of that is because our customers did a good job of conserving, as well as, our systems performed relatively well during the event.
There was a lot of discussion about conservation during specific dates in February as part of Mr. Zakura's questions. Do you recall whether Evergy answered a data request asking for usage by day in February of 2021, separated by customer class?
Do I recall if we responded to one?
Correct.
I do.
And I'm going to try to share my screen here. This is Evergy's response to NGTCC 1-6. Is that the data request that we were just talking about?
Yes.
And there is some confidential information in the attachment to this data request. I've redacted that for right now, just so the commissioners know. But does this data request contain an attachment that displays usage by day separated by class for February?
It does. That's actually the information I was referring to in Cross that Evergy had provided. That was the foundation for Mr. Gorman's work.
I would ask that Evergy Exhibit 1 be admitted at this time.
Is there any objection? Without objection, it's admitted.
Mr. Ives, you talked a little bit about the schools closing, I guess, and whether their usage reflected in a reduction or not with Mr. McKee. Do you know, was there any noticeable decrease in the school's class usage during the event?
For the class in total, there doesn't appear to be. When you look at, actually, Mr. Gorman summarizes it on page 12 of his testimony, where he showed non-URI February usage compared to average URI usage, and it doesn't appear to be that much different. In fact, it shows the school's URI usage is a little bit above.
You mentioned, I think in response to Mr. Zakura, and then also in your discussion with Commissioner French, that there's a special contract customer on Evergy system that requires some level of reduction when requested. And I think Mr. or Commissioner French mentioned that was Occidental Chemical. Is that correct?
That's correct.
And is Occidental participating in this docket through KIC?
Yes, they are.
And I think you talked to Commissioner French about this a little bit, but can you just briefly explain what's required of Occidental as far as reductions in usage under the EEDR tariff that they participate under?
Yeah, I would just say at a high level that there's a reduction in capacity that's required upon a 10-minute notice for a set number of curtailment periods. Part of the reason for the special pricing that they have in their contract is for their ability to meet that. Commissioner French alluded to it, but it's roughly an 80% reduction from their typical demand is what it calls for.
I would like to lodge an objection. May I, Commissioner?
Well, and what's the nature of the objection?
That the witness is not qualified to answer that question. There is a 24-page single space contract involving Occidental and KGNE that have many terms that interrelate, and whether or not and how those are affected in this particular situation is not something that he or anyone can testify to. It's a legal issue involving contract interpretation, and whether or not Occidental acted in accordance with the contract cannot be determined at the so-called high-level answer by Mr. Ives. It is giving a legal opinion on the fly of a contract that is far more detailed than anyone is stating here.
Chairman, I would suggest that as Vice President of Regulatory for Evergy, Mr. Ives is more than qualified to talk about the terms of the tariffs that we have on file with the Commission. But my next comment will probably address Mr. Zakura's concerns. I would like to ask the Commission to take administrative notice of the special contract between Evergy Kansas South and Occidental that was approved by the Commission in docket number 18 KG&E 303 CON, and the energy efficiency demand response tariff approved by the Commission in docket number 20 WSEE 123 CCN.
All right. Is there any objection to that?
Yes. I would state as follows. The rules of evidence 82.82-1230 for hearings and evidence refer the Commission to the rules of evidence of the Kansas Civil Procedure Act. KSA 60-409 indicates the facts which must or may be given judicial notice. Neither the contract nor the tariff are included in those items that the Commission may give administrative notice. The areas that the Commission shall give notice to are common law, constitutions, public statutes, and items universally known. The areas where the Commission may give judicial recognition and notice are acts of Congress and states, laws of foreign governments, facts generally known, laws of foreign contracts, and facts generally known from accessible sources. Neither the contract or the tariff fall within that. Specifically, 60-409 provides that only regulations of administrative bodies can be given judicial notice. This is not a regulation, it's rather a tariff. The other thing I would like to say is there's a lot of other things wrong with putting in the Occidental contract here. That contract was subject to a protective order in that docket. that docket provided that the documents in that docket cannot be used in any other proceeding. There is no provision under Kansas law for a judicial notice of a contract, a private contract between parties. There's no judicial notice provided for not for tariffs of an agency. And additionally, all of the orders that are included in the notice for request for judicial notice are not covered as well. These are clearly outside of 6409 and 6410, and the submission of the contract violates the protective order issued in that docket.
Ms. Dingus?
Thank you. I'll try to work my way through the various objections. I think Mr. Sakura seems to want to have it both ways, because he was criticizing Mr. Ives for attempting to summarize these tariffs and contracts. And so it seems like the logical solution for that would be to make sure that those items are in the record. As the commission knows, the special contract and the tariff were approved by commission order, and it's commission practice historically to allow for administrative notice of previous commission orders and other dockets. So I don't think that this is outside the realm of that precedent at all. Their witness has opened the door to this discussion by suggesting that his clients were able to make significant reductions. And so I think it's reasonable for the commission to be able to look at the actions of those parties that are participating in the docket, and to look at what the legal requirements were for them to act at the time. So I think it's appropriate for those to be admitted into the record from that perspective.
Can you address more specifically again for me the objections Mr. Sakura raised with respect to the protective order?
Yeah, I understand that the protective order would apply to discovery that occurred in the docket. What we're talking about here is the contract itself, which is not a typical contract, right? It's a commission approved document, essentially a tariff. And so the protective order would not prevent us from talking about the terms of that contract in other dockets. That's just unreasonable. Or we would never be able to talk about the rates that Oxy pays, in any other proceeding.
Mr. Sakura?
Yes, the commission, in our opinion, is bounded by the provisions of 6409. They make perfect sense. It states with specificity what can be taken, what kind of documents can be accorded judicial notice. Neither the contract does not fall in the list as set specifically out in the statute, or in the tariff. Ms. Dingus did say that they can talk about the order in the case. Well, that's quite different than putting the contract in the case, which is confidential, and even the commission's order leaves out the confidential issues. And we do not back away from the fact that there's nothing that I know of in commission precedent that would say that a private contract between parties, which has been given confidential treatment by the commission, can be provided in this document. I mean, it's as far as I know, unprecedented. But what really rules here is 6409 and 6410, which specifically says what kinds of documents that the commission may give judicial notice of.
And Chairman, I should clarify, we have no problem with making the contract confidential. I think that there are components of it that we historically treat as confidential. And so we could either redact it, or we could make the whole thing confidential, whatever the commission prefers.
That does not address the issue of whether or not the commission may give judicial notice, take judicial notice of a contract. There's nothing in Kansas law that allows that.
Chair, do you want to go into a brief deliberative session?
I do.
I think
I think what we will do is we will recess into a Zoom breakout session for the commission. We'll return as soon as that's over. There are a couple of other things I will just touch on before we do that administratively. It's the intention of the commission to finish this hearing today. We have 3 witnesses ahead of Mr. Gorman. I think Mr. Zakuri had indicated once we pass through this portion of the public record part, that the confidential portion would probably consume, from his perspective, about 5 minutes. So I'm thinking probably we'll resolve this issue that's immediately before us. I'm trying to finish with redirect if we possibly can. And I'm trying to be sensitive to you as well, Robin, and the concern that I have that we are 2 hours past the last break. So let's recess into a breakout session, and we'll return after that's over. Michelle, if you could help us get there, I'd appreciate it.
I'm gonna open the room and you guys should automatically be sent into it.
Thank you.
Denise, if you're on here, we're all returning. I think we were all sent to the wrong breakout room. Brian, you're on mute.
Yeah, we need the other breakout room, Denise, or Michelle, just with the 3 commissioners and myself. Thank you.
Okay, okay.
My apologies for us not being clearer on that.
That's all right. And it's kind of interesting. I cannot create two breakout rooms and have both people listed to it, so I have to switch them. Just a second here as the other room closes. You are moving now.
Okay, Michelle, if you're there, we need to go back from our breakout room to the, okay, let's see where we are. All right. Okay. Robin, are you good to go? All right. All right. At this time, we've returned from our breakout room. What we're going to do at this point is we're going to overrule the objection. The commission is going to take administrative notice of our own records as we're allowed to do under KAR 82-1-230H. We're going to respect the confidentiality of confidential records. That will not be breached by virtue of this particular action that we're taking here. So that is the position we're taking. As I recall, where we left off, Ms. Dingus, were you still conducting redirect?
I would like to make.
I'm sorry, Mr. Zucker, please.
I'd like to make a record objection. May
All
I?
right, very well.
KIC and NGTC and Occidental Chemical object and make this proffer of objection for the record. KAR 82-1-230 provides that the area known as taking judicial notice is subject to 60-409 and 410 of the Evidence Code of the state of Kansas. 60-409 does not provide for taking judicial notice of contracts. It does not provide taking judicial notice of tariffs filed at the commission. It specifically, to take judicial notice, you must come under the rules of evidence statute, which is 60-409 and 410. 60-410 provides that at C, that there shall not be judicial notice taken except those items which are listed under 409, and that the judge and the commission shall decline to take judicial notice if they are not included therein. And we do make that objection for the record, and we're ready to proceed further.
All right, thank you. Your objection is noted. Ms. Dingus. Yes.
Chair Keen, I'm sorry, this is Frank Caro on behalf of CDR. I would like permission to excuse myself for the rest of this hearing. Andrew Schulte with our law firm is also present and on this Zoom call, and I'm sure he's much better suited than I am to represent CVR in the remainder of this hearing, if that's okay with the commission.
Frank, you are excused. Thank you.
Thank you.
All right. I'm going to try once again. Let's see what happens. Ms. Dingus?
Thank you. Just a couple more questions. Mr. Ives, during your discussions with Mr. Zakura, you talked about whether Evergy had reached out to customers directly to request conservation. Do you remember that discussion?
I do.
And are you aware that Evergy provided a discovery response that detailed some of those efforts, conversations with customers and that kind of thing?
I am. I think there were a couple different discovery responses provided.
Okay. Pull this up. And I believe this does contain confidential information towards the bottom, but I've pulled up at least just the top so we can identify this. This is the Evergy response to NGTCC 1-1. Is that right?
That's correct.
And is this the data request that we were just discussing where there's information about Evergy's efforts to request conservation from customers?
Yes, it is.
And I'd ask for Evergy Exhibit 2 to be admitted into the record.
Is there any objection? Without objection, it's admitted.
And Mr. Ives, you also discussed, can't remember if it was with Mr. Zakora or Commissioner French, the earnings review and sharing plan filing that Evergy made recently. Do you remember that?
Yes, I do.
And that was in docket 19 KCPE 053 CPL. Does that sound right to you?
It does sound right.
And it was filed on March 31st of 2022. Is that right?
Yes.
And let's see. And I've just pulled that up on the screen. When it shows up, can you tell us if this is the earnings review and sharing plan compliance filing you were discussing?
Yes, that's it.
And I'd ask for admission of this compliance filing as Evergy Exhibit 3.
Is there any objection? Without objection, it's admitted.
And I believe that is all the redirects I have at this time. Thank you.
Okay, thank you. We want to try to conclude the public portion of Mr. Ives' testimony, the non-confidential portion, before we take a break for lunch, which I'm hoping will be in the not too distant future. We have covered a lot of ground. Mr. Zakura, since you last had the opportunity for cross-examination, I believe you're entitled to recross. So if you would, please do that.
Before we do this, do we need to be sure that to instruct IT that if we're going into confidential information, is that what we're?
No, we're not headed there.
Okay, I just want to be sure we're sorry.
What's going to, no, I'm sorry. Hold on, gang. What I intend to happen is that we're going to finish the non-confidential portion of Mr. Ives' testimony, and then we're going to take a break for lunch. We come back from that and we'll resume with that. Our goal again, and I will say we discussed this during the break that we took in the breakout room. Our goal is to have this hearing concluded by 5 o'clock. That is our goal. All right. Having said that, pardon all the interruptions here. Mr. Zakura, recross, I'm sorry.
And does that include recross based on commissioner questioning?
Yes, absolutely.
Okay. Mr. Ives, good afternoon.
Good afternoon.
I want to go back to some questions that Commissioner French asked you. Do you recall, number one, do you recall Commissioner French asking you about the Occidental contract?
Yes, I do.
And do you remember that he asked about provisions of compliance or non-compliance with that contract during the February winter crisis period?
I do recall that.
And do you recall that he asked about the tariff provision that is a part of that contract as well? Do you remember that?
You are referring to the EDR?
Yes, sir, I am.
Yes,
Okay.
I recall that.
And did Commissioner France ask you if Oxy was in compliance or non-compliance with the contract?
I don't recall the exact words. I believe he indicated his view on what that EDR called for, and I shared a response of the level that it called for, and that it was on a certain time of notice for a certain number of events.
And the certain time of notice and the certain number of events would be provisions of the contract. Is that correct?
I believe that's right.
Okay. And did you offer your opinion to the question of Commissioner French as to whether Oxy was in compliance or not in compliance with the contract?
I believe I did, indicated that they did not meet the level of curtailment that the contract would call for.
Okay. And is that based on your examination of the contract and legal advice?
Based on my examination of the contract, legal advice, discussion with key customer account representatives, yes.
And during part of the contract, Oxy was completely down. Isn't that right, during part of February?
They were substantially down. I'm not 100% sure if it was complete or substantially complete, but for a period of time, yes.
And you indicated, I believe, that during all times during February that Oxy did shed load at your request.
I don't think I indicated at all times during February, but during the requested periods in February, they did indicate an ability to shed some load, just not at the levels that the interruptible block and the EDR and contract would call for.
And would you agree that there might be provisions in the contract, such as force majeure or other provisions, when read together, which would affect Oxy's right or obligation to reduce load?
I don't know in the EDR that I would think that's correct.
I'm asking you about the contract, which includes the tariff edition.
Well, let me state it this way. I won't give my legal opinion on this topic here, but I've been informed that there's likely some difference in performance from what the contract in the EDR would call for.
And so that would be not your opinion, but someone else's opinion who told you that, correct?
Well, I certainly have engaged the advice of my counsel and my key customer contacts in review of the contract performance, yes.
And during the period that Oxy reduced load, that was the amount that they reduced load, as I understand it, would you confirm, was by agreement with Evergy?
It was through what Oxy informed us they would be able and willing to do. It was not necessarily what we asked for, but it was what they indicated they would do.
And is it your position, is it Evergy's position, that if Oxy informed you under the contract and pursuant to the tariff that's included, that reducing to zero would damage their plant substantially? Would it be your view of the contract that that should still happen?
I would suggest that there may not be allowances in the contract that provide for not meeting the interruptible section of that contract. That said, we certainly dialogued with Oxy and did not take actions to move them below the levels that they indicated they were comfortable getting to.
And we're talking about a period of mid-February, the 12th to the 17th, is that correct, of 21?
Yes, roughly that time frame, yes.
And in that year, more than a year period subsequent, you didn't assert any legal position that Oxy was in any fashion not in compliance with the contract. Is that correct?
Other than the discussions we're having here today, we have not asserted a legal position on that contract compliance.
Now, in your discussions with Mr. French, Commissioner French, about the Oxy contract, are you claiming that you have full knowledge of that contract and can speak to all the intricacies thereof? Or is that some kind of high-level opinion that you have that you responded to Commissioner French?
I've responded based upon the high-level knowledge that I have on that contract. I do not have all 20 some odd pages committed to memory.
Nor do I. Let me ask you another question, if I could, about, again, Commissioner French's examination. I have reviewed Mr. Gorman's testimony, as have you, and I see nothing in that testimony where he is suggesting that there will be a special charge, allocated charge across all customers on the system. My reading of his testimony says that the special charge would be only to those who are on the RECA and excludes the wind ECAs. Is that your understanding, or are you unclear about what Mr. Gorman is proposing?
I see nothing in Mr. Gorman's testimony that leads me to believe that it could be handled through the RECA. It will be a special charge line item on a bill, which I think calls into question how that charge gets applied. And I think Mr. Gorman is unclear as to how it would affect all classes.
And Mr. Gorman's, oh, excuse me, I didn't mean to interrupt you. Were you complete, Mr. Ives?
No, I was just going to say, and I think, you know, his testimony is silent as to the DRPS or the special contract customer that I discussed with Commissioner French.
And Mr. Gorman will be following on the stand. He's the best person. Would you agree he's the best person to answer that question about whether his allocation goes to those who would pay the RECA or to every customer, including those who have a wind ECA?
He would be the best person to share his perspective on the answer to that question, yes.
Wouldn't it be fair to say it's his proposal? So his proposal is as he will outline it to be, correct?
Yeah, although I think ultimately we will have to understand it at the Evergy level based on a commission order, so we would know how to bill it.
Now, let me ask you another part about the questioning of Commissioner French. Do you remember his question about the Spirit issue and the Spirit ECA?
Yes, I do remember the discussions on Spirit.
And in that discussion, did he indicate that Spirit's ECA was different than a RECA?
I think he indicated that they are served under a specific energy replacement component to their tariff that would make it different than the traditional ECA.
And when he asked you the question, would Spirit be charged for this, you stated that yes, Spirit would be charged. But as I understand your testimony now, your testimony is Mr. Gorman is silent on that and that he's the best person to answer that question. Is that correct?
That's not correct. I didn't say he would be the best person to answer the question. I said he'd be the best person to share what he intended with his position on that question. Ultimately, I think the commission will be the best suited to determine how a special line item on the bill would be reflected across all customers.
But we're only talking about, or I'm intending only to talk about Mr. Gorman's proposal for allocation. Certainly the commission will decide in its final order what happens. But as I understand what you said in your testimony just now, is that it's unclear what Mr. Gorman's intention is on how the allocation would be applied, whether it be applied to those subject to the RECA or to all customers. Is that correct?
His testimony is silent as to how he would address the renewable direct customers and the special contract customer Spirit.
So when Commissioner French asked the question, wouldn't this apply to Spirit or others who have a wind ECA? Mr. Gorman would be the best person to answer the question of what his allocation and what his proposal is on that point, correct?
Chair, I'm going to object. I think that's asked and answered about 3 different times.
I would sustain that.
Thank you. I have nothing further on redirect.
All right, thank you.
I do have some confidential evidence time.
Right, we'll treat those separately. All right, Recross Coffeyville Resources.
No recross. Thank you.
Thank you. Recross USD 259.
We have none.
Thank you. Further questions of the commission? Commissioner Duffy.
Thank you. Yes, Mr. Ives, I must have dreamed this, but I thought the company that we were referring to earlier had been charged for not meeting the requirements of the contract. And so why haven't you billed them for not meeting the requirements of the contract? I can't think of another instance where this wouldn't have been more appropriate to be used.
So it's a complicated question, but at this stage, we have not done that. Pending, obviously, the outcome of the discussions on recovery of these costs with the commission, and also considering the uniqueness of the event in question and whether or not it would have been incredibly punitive for them to make that level, to make that level of reduction and potentially caused harm to their system. So that's why we've not taken that step at this point.
Okay, so isn't these extraordinary circumstances? I mean, isn't this an extraordinary circumstance, Storm Uri? My understanding is, as a result of that being in the contract, that if they choose not to, and it appears they did not want to, that there is a charge. I mean, then, okay, they don't, and the consequence is then there is a charge to pay as a result. Because I think extraordinary events were contemplated for this extraordinary contract that they have.
I think that's a fair conclusion, Commissioner. I think I believe it would certainly be within Evergy's rights and or the commission's prerogative to have that contract and the terms of it enforced fully. I would just say that I'm not sure, while those contracts contemplated extraordinary events, I'm not sure that at the time it was entered, it could have contemplated that extraordinary event. That's a consideration that I think we have made at this point, but
okay,
it's a valid question.
Okay, and just one other question I have. We've talked about that there would be an extra charge if Mr. Gorman's solution was put in place, that there would be a separate line item put on the bills. And the company has stated that this would cost additional resources. Is there an estimate to that? I don't remember seeing that in the testimony that was provided.
Yeah, thanks for the question. I'm not sure that it's in the testimony. As I talk with the billing department and the IT team in our organization, they've indicated that it could take upwards of 6 to 9 months to put the work into place to get those charges on the bill, including work with our bill print vendor, and will likely, or will, if we do it, cause potential delays in current projects that are in flight, because we'll have to pull resources off. It entails IT work, design and planning, Commissioner. It entails audit and testing and validation work. And then the piece that obviously will be maybe most important is it will entail some very specific customer communications, because it'll be a new line item that customers won't have seen before, and a line item that'll represent costs from that were incurred at least 2 years before the line item shows up on a customer's bill. So we'll have to have some very specific communications developed and out to customers in advance.
Sure, but I think in our other dockets that we've considered related to Storm Uri, it didn't seem that an extra line item was insurmountable. Did you also just go to a new billing system as a result of the merger?
Yeah. Not as a result of the merger, but around that same time frame, we were started on that system before the merger, and we've implemented it across the system now. But we also have significant number of customers with quite a bit of system complexity that some of the utilities that have been before you might not have, whether it be Southern Pioneer or others. So there are certainly differences in systems and applicabilities as you get to scale. Commissioner, I want to be super clear. It is not insurmountable. If the commission says we will put a line item on the bill, we will get it done. It will not be easy or quick.
Okay, that additional information of 6 to 9 months and the cost might be beneficial to have more detail wrapped around that. I think with systems now, they're pretty adept at, going from vanilla to a little bit of Neapolitan. I mean, that's what they're designed for. So, okay, thank you, Mr. Ives. I appreciate it.
Thank you, Commissioner.
Thank you, Mr. Chairman.
Commissioner French, any further question?
The recross made me think of a couple items that I was interested in, but with the theme, I think they are actually more relevant to Mr. Gorman. And so let's move along. Thank you.
Very well. Thank you. I have no questions on recross either. Ms. Dingus, redirect.
No, Chairman, thank you.
All right, very good. Well, we have concluded now the end. We've reached the end of the non-confidential portion of your testimony, Mr. Ives. It is now, by my reckoning, about 1:40. Given the nature of what it is that we have before us this afternoon, I'm going to propose we're going to take a half-hour lunch break at this time. We'll resume at 2:10, at which time we will, as a heads up to our IT department, as soon as we resume, and we'll come back on this record with the full group, then we will move to a Zoom breakout room with all of those who have confidential credentials or NDAs. Having said that, we will at this time stand in recess until 2:10. Thank you.
Keene?
Yes.
Hi.
Yes, Susan.
Thank you. This is Susan Cunningham appearing on behalf of KEPCO, and I am respectfully requesting permission to not participate in the remainder of this hearing today. We are a full signatory to the settlement, and so our position, I believe, is on the record in addition to the other signatories to the document. And if I could be excused, I would greatly appreciate it.
At your request, you are excused. Thank you.
Thank you.
Okay. Very well. We're in recess. Off the record. Michelle, are you there? Robin, are you there? Robin?
Yep, I'm available. Sorry, I was on mute.
Oh, it's fine. Sometimes lunch breaks aren't long enough, no matter how long you make them.
Amen.
Okay. Are you ready to go again?
I am. Thank you.
Very good. Okay. All right. This time we're going to go back on the record. We're going to immediately go to a Zoom breakout room so that we may take the confidential portion of Mr. Ives' testimony. So Michelle, if you could move us to that breakout room, I'd appreciate it.
Opening the room now.
Well, some of us are returning gradually.
There could be some user error in rejoining if somebody hit leave meeting rather than leave closed session. So
Yeah, it could be any number of things. That's possible. You're right.
I'll go ahead and close the room. That'll force everybody to come back.
Well, that didn't help. There we go. Okay. Robin, I don't see you on the screen. Are you with us?
Here they all are now.
Rob, oh, there you are. Good. Okay. We have left the breakout room. We are now back in regular session. We're going to resume in regular session. We did conclude the confidential portion of Mr. Ives' testimony while we were in the breakout room. Mr. Ives, it appears that your testimony is at its conclusion here. I'm going to excuse you and thank you for your testimony. You may step down virtually.
Thank you, Chairman and Commissioners.
Okay, we're going to move on to our next witness. Mr. Zakura, would you please call your witness?
Thank you, Chair Keen. KIC and the coalition call to the witness stand Mr. Michael P. Gorman.
Robin, you're muted.
Hopefully we'll be back to normal before I ever get used to that.
I know, it's okay.
Mr. Gorman, can you hear me okay?
I can, yeah, but you can't hear me?
I can, thank you.
Thank you.
All right, if you'd raise your right hand, please.
Yes.
You do solemnly swear the testimony you are about to give in the case now in hearing will be the truth, whole truth, and nothing but the truth, so help you God.
I do.
Thank you.
May I proceed, Chair Keen?
Yes, you may, please.
Would you please state your name for the record, sir?
My name is Michael Gorman, Gorman.
And Mr. Gorman, are you the individual that prepared and filed 19 pages of testimony and exhibits attached thereto on April 29, 2022 in this docket?
Yes.
And on May 6, 2022, did you revise that testimony, but only insofar as making additional matters public pursuant to the agreement of KIC, the coalition, and Evergy?
I did.
And if I were to ask you the questions and answers that are included in your testimony dated April 29 as revised on May 6, would those questions and answers be the same as if you gave them live on the stand?
They would, yes.
Okay. Do you have any changes or corrections to your testimony, sir?
Just one comment. It's not really a change because it's been referenced a couple times here today already. That in table 2, that represents average daily use comparison between the URI usage periods compared to the non-URI winter event period in February of 21. I didn't note that in the table, and I'm hoping that was not confusing to anybody.
And Mr. Gorman, do you have any other changes or amendments, sir?
I do not.
With that, I would please, Chair Keen, move for the admission of the pre-filed direct testimony of Michael P. Gorman in this docket as filed on April 29, 2022, and as revised on May 6, 2022.
Very well. Is there any objection? Without objection, it's admitted.
With that, Chair Keen, I would tender the witness for cross-examination.
All right, thank you. Good afternoon, Mr. Gorman.
Good afternoon.
Let's turn first for cross-examination to Evergy. Ms. Dingus, please.
Thank you. Good afternoon, Mr. Gorman.
Good afternoon.
Good to see you again.
Nice to see you.
Mr. Gorman, you're aware that Evergy Kansas Central has agreed in the settlement to apply carrying charges at the rate of 1%, and that those would only apply at the time through the time they begin to collect the regulatory asset. Are you aware of that?
I am, and the rate is 1%, I believe, on those carry charges.
Right, thank you. And none of the other Kansas utilities that you talk about in your testimony that will have amortization periods longer than 2 years agreed to such a low interest rate. Isn't that correct?
Well, I don't know what the securitization interest rates were on some of those cases, but certainly none of them would have a 0% interest rate during the recovery period. So that would be correct.
And in fact, for Southern Pioneer, who you focus on, I think on page 17 of your testimony as an example, are you aware the commission approved carrying charges of 2.14%?
I need to confirm that, but that does sound correct.
The customer impact calculations that you do in your testimony, I think it's around pages 14 through 17, where you talk about sort of the different impacts of the different approaches on customers. You did not include any carrying charges in those calculations. Is that correct?
No, it was a 2-year amortization of roughly $119 million of a regulatory asset recovered in either 2 to 3 year period with no carrying charge. That's correct.
Okay, and do I understand your testimony correctly, though, that you are suggesting a 3-year amortization period with no change to the 1% rate that's in the settlement?
Well, the company would be allowed to recover a 1% carrying charge up until the point they start recovering the regulatory asset. But once the regulatory asset begins to be recovered, I have not challenged the settlement's allowance to the company of a 0% carrying charge during that recovery period.
And just to make sure I'm clear on your answer, the impacts to the customers you discussed don't include even that 1% carrying charge up until time of recovery, correct?
Well, consistent with what the settlement has agreed to, there's a 0% carrying charge during the recovery period. I did not include one in my estimated impacts.
Thank you. Mr. Gorman, beginning at the bottom of page 14 of your testimony, you argue that usage for the residential class for February 12th through the 16th was higher than other days of that month. And then you suggest that that creates what you call a windfall for the company. Is that correct?
Did I use the word windfall?
I think I saw that word in your testimony, but maybe I imagined it.
Yeah, I don't recall using that word, but certainly if usage for the residential class was significantly above normal levels, the company would not only incur higher fuel and purchase power costs to serve those energy sales, but it would also generate above average non-fuel revenue collections from that same group of customers.
Okay, let's talk about that just a little bit more. So in order to reach the conclusion that you reach about this offset you propose, I guess, based on residential usage, you base your conclusion on 5 days, the usage for 5 days out of the month, and just on the usage by the residential class. Is that correct?
Well, it's the period that Evergy has defined as the URI winter event period, both in your pleadings to the commission and Mr. Ives' testimony.
Do you have a specific reference to that definition, Mr. Gorman?
I do. In your compliance report of Evergy Kansas Metro and Evergy Kansas Central regarding cost incurred during winter weather event, this is dated July 2nd, 2021. Under background, it reads as follows. As is described in the direct testimony of Darren Ives, comma, attached here to is attachment A, comma, Winter Storm Uri was a major coast-to-coast storm that spread snowfall and damaging ice from the northwest into the south, west, Midwest, and northeast, February 12th through 16th, 2021, parenthetical winter storm Uri or cold weather event, close paren, with a footnote that states the date range for winter storm Uri is based upon SPP's conservation operation timeframe of February 9th through February 20th, 2021, I believe, but it's not stated in that footnote. That very same statement is offered in the attached direct testimony of Evergy witness Mr. Ives at page 3, with the same footnote that designates the determination of Evergy's definition of the winter storm Uri from that of the winter storm Uri based on SPP's conservative operation timeframe.
Thank you, Mr. Gorman. And so in order to support your proposal on this offset, am I correct that you looked at just residential usage during those days?
No, that's not correct. I considered the impact of usage across all rate classes during that time period relative to the full month of February 2021.
And that was with respect to your allocation proposal, right? But what I'm talking about is specific to this proposal you make, I think starting at the bottom of, you get the page right here, page 14, to look at residential usage and use that as an offset to the regulatory asset.
No, in assessing the class that had extraordinary usage during the Uri winter event as defined by Evergy is outlined on my table 2. And as shown in that table 2, the increase in daily usage for the customer classes was largely attributable to the residential and the small general service class. The other classes were either largely flat or slightly lower than they were during the other months of February. So that is the rationale I had for suggesting or concluding that the residential class and small general class were largely responsible for contributing to the extraordinary demand that existed during the Uri winter weather event.
Mr. Gorman, did you look at how the usage for the residential class compared to usage in prior years in February?
Well, I looked throughout the month of 2021 in February, so I did not compare that to prior years.
Did you compare it to the usage for the residential class during the test year on which rates were set or based?
From the last rate case?
Yes.
I did not, but I did look at the normalized projections that the company offered calendar 2022. And it's my understanding the company represented that those projections were a reasonable reflection of calendar usage during 23 and 24.
Did you consider any other events that may have occurred during 2021 that would have affected revenue the company was receiving?
Outside of February?
Anything other than Winter Storm Uri?
I did not examine it. I know there were other factors that impacted the RECA impacts, but that was not the focus of my analysis. Rather, it was simply an allocation of the extraordinary costs that were recorded to a regulatory asset and required a change in the RECA methodology to allow for recovery of a regulatory asset amortization cost.
And in fact, in February of 21, there were probably still more people working from home due to COVID at that time, correct, Mr. Gorman?
Say that's probably right, yes.
And that could have impacted residential usage in February of 21 then.
I would imagine that could contribute to the change in the demographics of the load forecast, yes.
Would you agree that the commission sets rates based on normalized weather?
Kansas Commission does, as well as all other commissions that I'm aware of.
And any given year, weather conditions fluctuate up and down around that normalized level, right?
Yeah, that's the purpose of setting rates based on normalized weather, normalized sales, normalized operating expenses, both fuel and non-fuel. for the very purpose that they can vary based on actual events that take place when the rates are in effect.
And this adjustment or offset or whatever you want to call it related to residential usage was not made in any of the other Winter Storm Uri dockets. Is that correct?
What adjustment are you referring to?
Your proposal to offset the regulatory asset based on usage of the residential class.
Well, no, I mean, many other cases, they've allocated the Uri winter storm extraordinary costs based on usage.
I'm not asking about the allocation generally, Mr. Gorman. I'm asking about your specific proposal to offset the regulatory asset by $3 million based on usage of the residential class.
I would ask that the witness be permitted to give his answer and not be interrupted by counsel.
I didn't interrupt him. I was just explaining the question. Do you understand the specific item I'm asking about, Mr. Gorman?
With respect to one part of my testimony where I recommended a potential non-fuel revenue increase offset to the under recovery of fuel cost. I'm not familiar with other proceedings that may have made that same or similar adjustment.
And you didn't cite any precedent for that adjustment in your testimony, correct?
Only that I think it's fair and balanced, consistent with other elements of the settlement. For example, the inclusion of extraordinary non-fuel O&M cost as part of this settlement. That's a single item adjustment that is included in the regulatory asset. So this is largely consistent with the makeup of the settlement, I believe.
But sir, you didn't include any precedent in your testimony specific to that adjustment, did you?
Other than it being consistent with other elements of the settlement, no.
Okay. Mr. Gorman, would you agree that Evergy Kansas Central did not have a mandatory time of use rate in effect for residential customers at the time of Winter Storm Uri?
I'd have to check, but I believe that's correct.
And none of the customers that you represent in this docket were taking service under a time of use rate at that time, correct?
That is correct.
And would you also agree that within each customer class during the event, that some customers made efforts to conserve and some did not within each of the customer classes on the system?
Yes, I agree with that.
Have you looked at usage for each customer individually in each class across the system?
I did by individual class, and to the extent customers within the class conserve energy, then they'd be allocated a smaller amount of the extraordinary cost than they would have otherwise been allocated had they not conserved energy. That's an allocation that is consistent and benefits each of the classes equally.
But I guess in response to my question, you didn't break down your analysis further than by class, correct? You didn't break it down to per customer.
I did not. I don't know if anybody looked on a per customer basis in this proceeding.
But you'd agree though, wouldn't you, that it's probably likely some customers in each class heeded conservation requests while some customers in each class were either maybe unable to or did not heed those requests?
I think that's the general assumption I'm using in my testimony to develop a fair and equitable allocation of the extraordinary cost.
Would you agree that customers in all classes were impacted by load shed, rolling outages that were called on by SPP, including both residential and larger customers?
I haven't verified that, but based on Mr. Ives' testimony today, it's based on a predetermined structure for the rolling outages. So I imagine it is consistent with how Evergy implemented those response to the recall for mandatory conservation.
And all of the customers in all of the classes across the system were facing with and dealing with the bitter cold temperatures during Winter Storm Uri, correct?
They were, yes.
For the larger customers that you assert had lower usage that curtailed, did you do any analysis of whether they met requested curtailment levels from Evergy when they were contacted?
I didn't, because my allocation would require them to pay for the power that Evergy, the cost of the power that Evergy incurred, to the extent they did take power during the Erie winter event. So customers that took power paid for it, and that would reflect whether they were or were not able to curtail their load in response to the emergency conditions.
But again, your proposal is by class, correct? It doesn't break it down beyond that.
That's true, but the companies and the staffs is by system, which has less granular allocation than mine. And I think it's a reasonable method that it generally aligns with balancing the interest of the various types of customers on the system.
Mr. Gorman, did you, as part of your work in this docket, do any review of whether customers were actually curtailing usage based on conservation requests from either Evergy or the governor or the commission, or if maybe their operations were shut down due to natural gas curtailments or other factors? Did you look at the reason for any of those reductions?
I did not. My analysis simply allocated cost to customers that use power to pay for the power they used. And other customers that didn't use power would, or at least the classes that didn't use as much power, would not pay for power that was procured for the benefit of other classes.
So you don't know today whether the lower electric usage that you're claiming for some of these customers was a result of, good faith conservation efforts or some other cause and was actually just an unintended byproduct. Is that right?
I can't speak to the intention of the level of load that was used by each of the rate classes, but my analysis will require those rate classes to pay the cost of the load that was taken during the winter event.
All right. Thank you, Mr. Gorman. That's all I have for now.
Thank you.
Thank you, Mr. Davis. Cross-examination, Curb.
May it please the commission, Curb has no questions for this witness.
Thank you very much. Cross-examination, KCC staff.
Sorry for the delay there, Chair Keen. Again, working with multiple monitors here, so I appreciate a little bit of patience. I just have a couple of questions for Mr. Gorman. Mr. Gorman, I would start by saying good afternoon and thank you for your participation in today's hearing.
Good afternoon and thank you.
Mr. Gorman, would you agree that in February of 2021, there were still generally a large amount of employees across Kansas that would have been working from home?
I haven't verified that, but based on my understanding of work methods at that point in time, I think it's a reasonable assumption to believe that that's a fair conclusion.
Thank you. As part of your analysis in this docket, did you uncover or look into how many, if any, KIC, NGTCC, or schools employees were working from home during February of 2021?
I have not, same answer, I have not made that evaluation, although a lot of employees of industrial companies need to be on site. So I don't know if it's as likely that they would have the option to work from home as many other professions. Same with school teachers, employees of school districts.
Okay, thank you. That concludes my cross-examination.
All right, thank you. Let's see if we have commissioner questions. I'll begin with Commissioner Duffy.
Thank you, Mr. Gorman. So it seems to be that there's this line of questioning to you about not having looked at the details of each class or a better understanding. Would you like to reflect on that? I mean, is that consequential in the development of your plan as you've shared it?
It is not consequential to know the actual effect of each customer individually's response to emergency requests and the cold weather events. What I've looked at is how much demand was placed on Evergy, which required them to go into the market because some of their own generating resources were not available, or if there wasn't enough contract gas supply available, they were forced to go into a very expensive market to buy additional gas to generate electricity, and either buy or generate electricity in sufficient quantity to meet the demands by their retail customers, or all the customers that are subject to the fuel adjustment clause under the RECA tariff. And then go into a two-part analysis, which is consistent with the settlement. One is to identify how much of that total of fuel and purchase power cost incurred in February 21 should be considered normal and should flow through the RECA and the ACA as a normal course of business, and how much of that cost should be separated as extraordinary cost, recorded in a regulatory asset, and then amortized cost of service with an adjustment to the RECA and the ACA in subsequent periods. With respect to the normal level of cost, which could be impacted by high market conditions to the extent they had to go and buy additional gas to meet the normal level of energy, or whether or not they had to buy power to meet the normal level of energy, those costs would be flowed through the RECA and the ACA under the terms of the settlement and under my proposal. The primary difference between my position and that of the stipulation is how the extraordinary cost incurred in February 21 would be spread across the rate classes. The stipulation requires a uniform recovery of that on a kilowatt hour basis across all rate classes, irrespective of what their load was during the Uri winter event. Instead, they want to spread it over projected calendar year kilowatt hour sales in a period up to almost 2 years after the winter event occurs. My concern is that does not charge the customer classes that caused Evergy to incur those extraordinary costs for the demands they placed on the system, which caused the need to incur those costs. So it's not a cost allocation methodology that assigns the cost to the customers that required Evergy to incur those costs during those extraordinary costs during the Uri winter event. The stipulation simply spreads those extraordinary costs to customers based on normalized load conditions in a subsequent period, without regard to the extraordinary conditions and the extraordinary demands placed on the system during the Uri winter weather event. I think it's imbalanced because it doesn't assign the cost to the customer groups that cause those costs to be incurred.
Okay. In your testimony on page 17, down at the bottom, line 21, line 22, you're referencing Oklahoma Gas and Electric and Public Service Company of Oklahoma both received authority from the commission to recover extraordinary Uri winter event costs, and they developed class energy allocation factors for these costs based on customer usage that occurred during the Uri winter storm event. Did you participate in this proceeding?
I didn't, but somebody from my firm did.
So are they is your proposal mirroring what Oklahoma chose to do, the Oklahoma Commission?
It's similar in some respects. However, in Oklahoma, they use securitization bonds in both cases. And the allocation of the securitization bond charges to customer groups aligned with customers' demand during the winter event. So the allocation of the cost I am proposing here is similar to some aspects of what took place in Oklahoma, but the objective of that was approved by the Oklahoma Commission is what I'm recommending to you here, and that is the customers. The cost of the extraordinary winter event should be allocated to customers in line with their demands on the system during the winter event, because those demands are what caused those costs to be incurred.
Okay, so if your company participated on behalf of whom? The company?
I think it was the Oklahoma Industrial Group.
The industrial group in Oklahoma. Okay. Yeah. Were you involved in any other, or your company involved in any other Storm Uri dockets?
I believe we have been involved in some in Missouri and in Arkansas.
Okay. All right. Let me look here. I think that answers all of my questions. Thank you, Mr. Gorman. I appreciate it.
Thank you, Commissioner. You're welcome.
Commissioner French.
Thank you. Hi, Mike. Good to see you and hear your voice again.
Thank you, Andrew. It's nice to see you.
Well, I have a few questions that I think I started to explore with others, but they really are best for you to understand your position, as Mr. Zakura said. First of all, I think you cleared this up with Ms. Dingus, but just with reference to that February 12th to 16th date that you used to create your allocation, it's my understanding, based on your answer, that that was based on how Evergy had defined the time period of Winter Storm Uri. Is that within one of their filings? Am I kind of hitting the essence of it?
Well, yeah, that was the major issue. That's what they told us the Uri winter event period was for Evergy. But I also looked at other aspects of their data to confirm that that's a reasonable period, and I concluded it was. Specifically, the daily class usage that the company submitted as a data is a hearing exhibit from Mr. Ives earlier, illustrates that the demand on the system was quite a bit higher and during the period February 12th through 16th than it was throughout the rest of the winter event period that was designated by the Southwest Power Pool, which was February 9th through February 20th. So that was consistent with a very, very extreme level of demands that were being placed on the system that were causing emergency conditions in the Southwest Power Pool. And that was also consistent with the heavy demands for Evergy Central during that same time period. Also, if you look at page 4 of Mr. Ives' testimony, he referenced a table that kind of gives a timeline of the SPP winter event time period of February 9th through February 20th. And during the period February 12th through about the 16th, which is the time period that they defined as the Uri event winter period, that was the period where the significant emergency events were taking place inside the Southwest Power Pool. And it's also consistent with most of the period where we saw extremely high levels of power and gas prices.
I'm sorry, that was going to be my only follow-up. Was it sounds like the 12th through the 16th is heavily intertwined with the period of extraordinary demand and extraordinary operations. But I guess I'm focused in on the period of extraordinary cost, and is that period fully encapsulated within the 12th to the 16th, or is that a little broader date range?
Well, there was extraordinary cost throughout the entire winter event. So it might be outside the 12th through the 16th. 17th, I believe, had some very high power costs and natural gas costs. They were a little lower beyond the 17th, if I recall correctly, and they kind of built up within that 12th to the 16th time period. But there's also, because of the load on the Evergy system, we heard that the company during parts of the winter storm were buying power under onerous conditions, very high power prices. But other parts of the winter event, they're actually able to sell into the market and generate revenues. Well, I didn't confirm this through discovery with the company, but just based on their load characteristics and the amount of generation available, it seemed like they probably were able to sell power and earn margins during the winter, the SPP winter event period outside of the 12th through the 16th. So all of that was kind of part of my rationale for supporting Evergy's contention that for it, the Uri winter event encapsulated the 12th through the 16th time period.
Okay, thanks. That was, I think, the clarification I needed of, where it was coming from and what underlies the 12th through the 16th. Let me turn to, I really only have kind of one other line of questioning, and it's going to go to your recommendation of a new allocation and a new sort of line item charge on bills. And I guess first, one of the specific items that I know was important to your council was to ask you, what was your recommendation? Because I think there was discussion that you were silent in your testimony as to which customers the line item Uri surcharge would be charged to, and whether it would apply to all customers or whether it would apply to only those customers paying the RECA. In other words, you would exempt folks that either have a special contract or are paying a different energy cost, exempting them from the RECA. And did you hear that discussion earlier today?
I did, yes.
And I guess just for simplicity's sake, as briefly as you can, what was your intent?
My intent is for the customers that are obligated to pay the fuel adjustment charge portion of the RECA, and I believe that's consistent with the stipulation in this case, will get an allocated share of the extraordinary power cost. It was an error for me not to design the data request to Evergy to exempt, to separate special contract customers that were non-requirement customers, would not be subject to the fuel adjustment component of the RECA from the other special contracts and all the other classes of customers and wholesale customers that are subject to the fuel adjustment clause.
So go ahead.
Mr. Ives stated that my analysis would have to be corrected for that point, and I agree with that.
Okay, that was going to be my next question. I just looking at table 3 in your testimony on page 13, and I don't believe this table is confidential. This is the allocation that you're recommending. And would it be fair to say that if you did remove all the customers, which would primarily be large customers that are not paying the ECA, if you remove those from the large general service class, medium general service class, and then you remove the special contract customer that does not pay the ECA, that the residential and small commercial allocations would go up materially?
I would have to review that to confirm that, but there certainly would go up if we're spreading it over fewer kilowatt hours, yes.
And so I don't think this is saying much, but just moving down to page 14, where you have calculated the bill impacts to residential customers. If we were to exempt out those, the customers we've discussed that are not subject to the ECA, those bill impacts would be higher than what's stated in your testimony right now, correct?
They would be, but I think the number I have at page 14, line 11 for residential class is pretty close to what the company and the staff have estimated for a typical impact on residential customers. So I don't think it's that significant impact on residential customers by correcting it. It looks like about 7 cents a month.
And that I'm going to ask you a more theoretical question and just ask you to to bear with me and be as candid as you can. I certainly understand your position. I understand the settlement position. It seems like the settlement is taking a position of, look, this is how costs would naturally be allocated if we hadn't done something extraordinary here. They would have flowed in this way, and so we're just going to keep with that allocation. I think you are taking the position of, look, we're setting this aside and we are doing single issue rate making, and so it's an opportunity to get a little more granular with the cost allocation. If we're going to be granular on viewing the costs. And so my question is this: if we are going to get granular, what is the justification for exempting the customers that currently don't pay the ECA? They were part of the system during Winter Storm Uri. They used energy during Winter Storm Uri, and it probably can't be directly related to a particular supply during that emergency event. What is the justification to exempt them if we are going to try to get granular and we're not just going to stick the allocation as it would have been under the status quo?
Well, I think the assumption that I'm working under is that the amount of fuel and purchase power cost incurred by the company to serve the requirements customers is what was used to identify the amount of the extraordinary cost that then would be collected from those requirement customers. I don't think the settlement identified any additional cost or the consequences for the non-requirement customers. So those two cost items are separate. The cost of serving non-requirement customers is explicitly removed from the RECA tariff in developing the annual cost adjustment. And no party proposed to take issue with the amount of cost incurred to serve the non-requirement customers. And frankly, I simply did not dig into that issue to determine whether or not there is any concern with that methodology. So I'm working under the assumption that they are paying the cost they incurred to receive power during the winter storm event. And I think it's fair and consistent for other customers to also pay for the cost of power they received.
So as I understand the answer, it's sort of, you took it as a given that was a reasonable approach under the settlement, and so it would be reasonable to also exempt them out under your methodology.
I did not challenge the amount of money to recover from the requirement customers. And I'm not aware of anybody else challenging that aspect of the settlement.
I think that is every question I had for you, Mr. Gorman. Thank you very much.
Thank you. Great seeing you again.
Same.
Mr. Gorman, thank you again for being here. I have 3 questions for you.
Okay.
The first of these is this. Evergy and other proponents of the non-unanimous settlement agreement contend that your proposal would unfairly impose a retroactive time of use rate on residential ratepayers. I would appreciate your response to that contention.
Well, I think it's an unfair characterization of my proposal. The RECA and the ACA adjustments are being modified to account for the extraordinary cost and extraordinary circumstances of the Uri winter weather event. They're proposing to create a regulatory asset for these extraordinary fuel and purchase power costs incurred by Evergy during that period, and to adjust the annual cost adjustment in the RECA tariff to allow for amortization of those costs over a specified period of time. So they're recognizing these are not normal annual recurring type costs, but they're extraordinary in nature, where all customers came together to do whatever they could in order to keep the system up and running, to keep at-risk customers electrified, and to push through this to the best of their ability. For a lot of industrial customers that are able to curtail, they have economic consequences to those customers. They have lost business production. They may have their own extraordinary maintenance expense to bring their power down and then bring it back up very quickly. There are costs to industrial customers to swing their load as they to the best they can in response to these emergency conditions. So those customers are being asked to pay cost that is in excess of the amount of cost the utility incurred to provide them the power that they needed during the Erie winter event, reflecting those abnormally low usage areas, or those no increase to, in some cases, reduced usage during the winter event, and to subsidize other customers that have well above average usage characteristics. That imposes significant cost on those customers, both in the allocation of the cost of the extraordinary winter event cost across all customer classes, and also potentially the cost that they incurred in order to do everything they could to reduce load in response to these emergency conditions. I just don't think that's equitable.
All right, thank you for that response. My last two questions have to do with the amortization period. Were you present this morning during Mr. Ives' testimony?
Yes.
Okay. In particular, I want to go to a part of the pre-filed testimony from Mr. Ives. This is the pre-filed of April 29th, 2022. In particular, we're on page 16, if you could find that.
Page 16 of my testimony?
No, it'd be Mr. Ives' testimony. Do you have that handy?
I'm sorry, I do not, no.
Okay, it's okay. I'll read the portion of his pre-filed testimony that's germane to my question. It appears on page 16, against the pre-filed testimony of April 29, 2022. It's lines 13 through 16, and I'll read those for us. Quote, in addition, as the commission is, I am sure, fully aware, interest rates are currently rising, and if the amortization period were extended to longer than 2 years, it would be necessary and appropriate to allow application of a higher interest rate over that longer period. Longer amortization periods would require longer-term financing arrangements, end quote. As you may recall, I was asking about Mr. Ives' thoughts on what might happen in the event that the commission were to adopt your proposal and extend that amortization period to 3 versus 2 years. In light of that, I would appreciate your take on the probability of the higher interest rates in that 3rd year that Mr. Ives is suggesting through his pre-filed testimony, and I believe in response to my question this morning.
Well, I think we need to look at it from terms of both how short-term interest rates or even long-term interest rates are being impacted by the current macroeconomic environment. They are increasing. You know, the Federal Reserve has been tightening monetary policy in order to slow the economic growth and try to curb inflation. That has caused both short-term and, to a lesser extent, long-term interest rates to increase. Westar has the ability to use short-term facilities in order to fund these extraordinary costs that they want to include in a regulatory asset. And I haven't confirmed this with them, but most utilities are able to lock in a specified amount of short-term borrowings, which would be somewhere between 2 and 5 years based on current market environment. The interest rate to lock that in today would be a little higher than it would have been 6 months ago, but probably would be less than what the interest rate will be a year from now. So to the extent Evergy is concerned about the increase in interest rates and the cost of carrying that regulatory asset over the 3-year amortization period, then they have ability to mitigate that uncertain cost by locking in the interest rate right now. They already have a pretty good idea of what the amount of the regulatory asset is. So they can manage that exposure, with their short-term borrowing facilities and agreements with banks. So they don't need to leave themselves open to changes in interest rates over the entire amortization period, because with their bond rating and their credit standing, they likely can lock that interest rate in based on at least today's rates. Unfortunately, they should have done it 6 months ago, where the rate would have been much cheaper, but it's still a relatively attractive rate based on the market cost today. Whether or not they can recover that carrying charge kind of goes with the structure of the amount of the non-unanimous stipulation, which we didn't challenge, because in that stipulation, all stakeholders have a little skin in the game. Customers for their own facility cost as they curtailed power, they can't recover those by reductions in their electric bills, but they will compensate Evergy for the cost of purchase power and fuel costs during the winter event. Evergy's skin in the game is to reduce the carrying charge and the impact on the customers. And they've already agreed to do that over a 2-year period in order to achieve the mitigation of the impact on residential customers under my revised allocation, which asks all customers to pay the cost incurred to serve them. Evergy would be in a position where they'd have to assume one additional year of carrying cost for that regulatory asset amortization.
Okay, thank you for your response. My final question, as I suggested, has to do with amortization again. Mr. Gorman, how would your 3-year amortization period, if implemented, affect the Evergy Metro customers and the rebates that they're entitled to?
It would have no impact on Evergy Metro, a portion of the non-unanimous stipulation.
Okay. Well, that concludes my questions. Mr. Zakur, we'll turn back to you for redirect, please.
I have no redirect. Thank you.
Okay. We have had, again, as was the case with Mr. Ives, we've had a few questions here from the commissioners and a few other questions that have arisen since you had an opportunity to ask questions. Ms. Dingus, do you have any recross?
Just briefly, Chairman. Mr. Gorman, I just wanted to confirm, I think I heard you say when you were just having the conversation with Chair Keene about, whether Evergy could lock in interest rates for a period of time and so on and so forth. I think I heard you say you didn't get any of that information from Evergy in this docket, correct?
I did not confirm that with Evergy, that's correct.
And you're not familiar at all with the details of Evergy's program as far as, commercial paper or issuing short-term debt, right?
I did not look at that specifically for this case, that's correct.
Are you aware that the rate Evergy's paying for commercial paper is already above 1% today?
Today, I would not question the accuracy of that.
Thanks, Mr. Gorman. That's all I have.
All right, thank you. Mr. Gorman, I believe we've reached the end of your testimony. At this time, you will be excused. We appreciate very much your testimony. Thank you for your appearance.
Thank you. Appreciate it.
All right. We'll move next to our next witness. It was Patrick Orr on behalf of CURB. Mr. Nickel, would you please call your witness?
Yes, CURB would call Patrick Orr to the stand. May I proceed?
Once I swear him in, please.
Thank you.
Mr. Orr, can you hear me okay?
Yes, I can. Thank you.
Thank you. Raise your right hand, please. You do solemnly swear the testimony you are about to give in the case now in hearing will be the truth, whole truth, and nothing but the truth, so help you God.
I do.
Thank you.
Would you please state your name for the record?
Yes, sir. My name is Patrick Orr, O-R-R.
By whom are you employed?
I'm employed by the State of Kansas Citizens Utility Ratepayer Board, otherwise known as CURB.
What is your business address?
1500 Southwest Arrowhead Road, Topeka, Kansas.
In what capacity are you employed by CURB?
I'm a regulatory analyst, sir.
And did you cause to be pre-filed in this docket testimony in support of non-unanimous settlement agreement dated April 29, 2022, consisting of 26 pages?
I did.
And if I were to ask you the questions that are contained in that pre-filed testimony, would your answers be those that are contained therein?
Yes, sir.
Do you have any revisions at this time?
I do not.
I would tender this witness for cross-examination.
Did you want to offer his testimony, pre-filed testimony?
Yes, thank you. I would offer the testimony, pre-filed testimony of Patrick Orr into the record.
Is there any objection? Without objection, it's admitted. Very well. Good afternoon, Mr. Orr.
Good afternoon, sir.
Mr. Zakura, a cross-examination, please.
Thank you very much, Chair Keen. I have no questions for this witness.
Thank you. Coffeyville Resources, cross-examination.
No cross-examination. Thank you.
Thank you. USD 259, cross-examination.
Yes, just one question, Your Honor. Sir, on page 24 of your testimony, line 9, you say that you give a rate per month of $2.80 collected from the average Evergy, Kansas Central ratepayer. You really mean to say the average residential ratepayer in that line, don't you?
I believe so, sir.
That's on page 24, line 9.
Yes, sir. It says in a vacuum, the $2.80 appears reasonable given the fact that customers of Evergy, Kansas Central did not suffer any extended outages. It goes on from there.
Well, my point simply is this. You make reference to the $2.80 per month charge for the Evergy's Kansas Central ratepayer. You mean the residential average, do you not? Not the average customer, the average residential customer.
Yes, sir.
All right. Thank you. That's all I have.
Yes, sir.
Thank you. Let's see if we have any commission questions. Commissioner Duffy.
Thank you, Chair Keen. And while I understand this proceeding is really about the components of the disagreement between the non-unanimous and the other aspect of this case, I do have to ask you about one aspect of this, Mr. Orr, that CURB would be involved in, and that is related to the low-income assistance, where Evergy contends they will have a discussion and work with parties related to a low-income assistance rate. Have there been, this isn't the first utility to bring it up that was affected by GIE. Have there been any discussions to date about low-income assistance, period, just in general, between this company or staff related to low-income assistance rates?
Thank you. Yes, ma'am. CURB staff, several utilities, Atmos, Evergy, others have had several meetings on low income rates. The other several utilities have described what they've done in other states. But as far as any concrete details for Kansas, no. But we have had discussions with utilities. They have agreed to work with CURB and staff to make that happen.
That's sounds very promising. Have you reached out to anybody in the Kansas community to talk about low income assistance rates?
Yes, ma'am. I personally have spoken to several entities here in Topeka about low income rates and what they've done. That's as far as I know that we've carried it, though.
Okay, all right. And it's my understanding that CURB is a signatory to the non-unanimous settlement, and that CURB supports the recommendation in total of the non-unanimous settlement.
That is correct, ma'am.
Okay, thank you, Mr. Orr.
You're very welcome. Thank you.
Commissioner French.
Good afternoon, Mr. Orr. I wanted to say good afternoon, but I have no questions.
Good afternoon, sir, and thank you.
Thank you.
Mr. Orr, I have no questions either. Let's see if we have any redirect. Mr. Nickel?
No redirect. Thank you, Your Honor.
All right, very well. Mr. Orr, I believe this concludes your testimony. You may stand down. You are excused, and we appreciate your testimony.
Thank you, sir.
Hey, may I request, may we have a 5-minute break for restroom at this point before we start the last witness?
Well, you're going to request 5, but I'm going to give you 15. let's take a break here. It's been a while since we've been plowing along here. By my reckoning here, it's 3:40. Let's try to resume here about 3:55. We're off the record.
Thank you. Thank you very much.
All right. And it's 3:55. And Robin, are you good to go?
Good to go. Thank you.
Very good. Okay. We'll go back on the record at this time. It's 3:55. The final witness for this evidentiary hearing is the KCC staff witness. Ms. Mesenthin, if you would, please call your witness.
Yes, thank you, Chair. At this time, I would like to call staff's witness Justin T. Grady.
Mr. Grady, can you take it off mute for me?
Yes, ma'am. I think you should be able to hear me.
Oh, I can. You're right. You do solemnly swear the testimony you are about to give in the case now in hearing will be the truth, whole truth, and nothing but the truth, so help you God.
I do.
Thank you.
Good afternoon, Mr. Grady. Would you please state your full name and business address for the record?
Yeah, good afternoon. My name is Justin T. Grady. My business address is 1500 Southwest Arrowhead Road, Topeka, Kansas, 66604.
And please state your title and position at the commission.
My title is Chief of Revenue Requirements, Cost of Service, and Finance. I work in the Utilities Division with the Commission.
Thank you. Did you cause to be filed staff's report and recommendation in this docket on January 21st, 2022?
I did. Yeah, I was one of the authors of that report. The other authors of that report either report to me directly or were also involved in the preparation of that report. I think Leo Hanos's name is on that report as well.
Thank you. And did you cause to be filed in this docket staff's testimony in support of the non-unanimous settlement agreement on April 29th, 2022?
I did.
Did you have any exhibits to that testimony?
I think there were exhibits attached. Yes.
The exhibit attached to your testimony is the public version of your report and recommendation, correct?
That's correct.
And was there also a confidential version of that report and recommendation filed as well on January 21st, 2022?
There was.
Okay. Do you have any corrections to make to either staff's report and recommendation or to staff's supporting testimony today?
Not at this time.
And if I asked you the same questions today as were contained in your supporting testimony under oath, would your answers be the same?
Yes.
Okay. Thank you. Commissioner, staff moves that staff's report and recommendation, both the public and confidential versions as filed on January 21st, 2022, as well as the testimony in support of the non-unanimous settlement agreement filed April 29th, 2022, both authored by Justin T. Grady, be incorporated into the evidentiary record in this document.
Is there any objection? Without objection, they're admitted.
Thank you. I tender the witness for cross-examination.
All right. Good afternoon, Mr. Grady.
Good afternoon.
We'll turn first for cross-examination to Mr. Zakura.
Good afternoon, Mr. Grady. I have no questions. Thank you.
Thank you.
Coffeyville Resources, cross-examination.
No questions. Thank you, Commissioner.
All right. USD 259, cross-examination.
No questions, Your Honor.
We'll see if we have any commissioner questions. Commissioner Duffy.
Thank you, Chair King. Hey, Justin, good to see you.
Good to see you, Commissioner. Good afternoon.
Justin, so a lot of the questions this afternoon and today have been about single issue rate making, and this gets about as close to it as you can. So why, when we have Mr. Gorman's testimony that takes data, actual usage data, and applies it in terms of a proper way to ensure that everyone pays a fair share, why just should not this be used?
Yeah, so thank you for that. So the biggest problem that I have with Mr. Gorman's recommendation, there are several observations that I have or criticisms of the specific approach, but probably the biggest analytical criticism that I have is that it's not a period that's representative of the extraordinary costs. Okay, so it may be a period that's sort of loosely representative with the most extreme system conditions, at least from an electric system perspective. But then you have to ask yourself, well, why not just use the 15th and the 16th of February? That's when we actually had controlled service interruptions, right? And of course, we were still in an EEA2 or an EEA3 on the 17th as well. But for some reason, the 17th is excluded from Mr. Gorman's recommendation. So, you know, I think that's a pretty severe deficiency and a pretty major criticism that I would have of the approach. You know, I think I have several reasons why ultimately, you know, we didn't entertain an approach similar to that. You know, the other major concern I have with it is I just think it's too narrow of a time frame. I mean, if you asked me today to choose 5 days that were the best 5 days, I mean, I would say something like February 14th through the 19th from an electric power market perspective or wholesale power markets. But I would still disagree with the need to select 5 specific days out of the month of February 2021 to derive a extraordinary winter storm Uri charge. I just think that's far too narrow of a period of time, personally. You know, there are other reasons why I think it's appropriate in this instance to just socialize these costs in the fashion that we have through the ECA. But, you know, and then we could talk about if the commission actually wanted to go down the direction of some sort of a class allocation approach. I think, you know, the smallest period of time that I would probably recommend looking at would be the entire month of February, which is something that we've done in other cases, other dockets. But that's not a recommendation that we have, and we can talk about why. But I have the most concern with those specific days, February 12th through the 16th.
Okay. So why did you not select the 28-day time period for February then, since you've raised it?
Sure. Yeah, great question. I mean, great question. You know, in this case, we were the first party to respond to Evergy's compliance file, right? And Evergy, the commission said in the emergency order, we have extraordinary costs. We are ordering you to isolate those extraordinary costs and bring forward a plan to spread out the impact, the financial impact of these costs to your customer base, right? Over a reasonable time frame. You know, we can look at what the exact wording was of the commission order, but essentially it was a reasonableness standard that was presented in my mind. And so we looked at, as you know, I mean, we filed a detailed and comprehensive over 100-page R&R in this docket, and we looked at the costs that they incurred, and we looked at their plan, and we said, you know, this is a reasonable plan. This plan reasonably spreads out the costs of the event to customers. It results in in an affordable bill impact from a residential customer perspective. And our recommendation at the time was, well, we still have some additional items to talk about. We need to talk about carrying charges and some of the other sort of, more nebulous type issues, which is what we recommended to enter into discussions. But the reason that we didn't bring up class cost allocation or a specific class delineation of the costs in this docket, honestly, comes down to the relative materiality of the costs. We tried to Miss Massadine, we tried to focus on that in the opening statement, because it really was a significant part of why when we filed our original report and recommendation, we didn't raise this as a bigger issue. That wasn't one of the issues that we said we can't use the RICA. We need to develop a separate line item surcharge, and we need to figure out who's going to pay for this. And it's unbelievable, really, to say that that a 25% of an annual fuel expense is not as material as what other utilities incurred, but as you know, it's a fraction of what other utilities incurred, right? And it was $119 million, and compared to a $500 million total fuel and purchase power bill for a year, it's not that bad. It's not as extreme as what some of the other utilities faced. And there are a lot of different arguments to make regarding the appropriate class allocation or how you spread these costs out. But one argument that I think deserves some deference and some attention is the idea that but for the commission's action to create this regulatory asset, these costs would have been recovered through the RECA tariff. There is an existing tariff that calls for how to recover these costs. And, this whole relative materiality argument, you look at the fact that we're talking about $119 million worth of costs here spread out over 2 years. But as you know, the non-URI under recovery for 2021 in that other ECA docket was $116 million. And there isn't any effort, detailed effort to go in and try to determine which classes of customers were using usage more when natural gas was higher, last fall. It's just the normal course of business is just to socialize these costs through the RICA. And I think it was just maybe not a perfect decision, not an objectively or quantitatively determined decision. It was just a policy decision of, why don't we just use the RICA for the cost recovery, for the under recovery for these costs? It's probably okay in this instance. So that was really it.
Okay. Thank you. Another subject that was a large part of our discussion this morning revolving around one company's contract with Evergy and whether they should, apparently they did not meet the requirements of their contract, and there has been no charge levied to this company, according to Mr. Ives. So can you share your thoughts surrounding this? For some reason, I thought that they had paid a charge back. So I guess I don't know where I got that impression, but.
Sure. So yeah, I mean, we certainly issued discovery about all of the interruptible customers and their response during Winter Storm Uri and conservation efforts and the difference between voluntary and sort of involuntary curtailments and all of that. And you know, I guess I do agree with the idea that if we are going to have a more granular customer by customer or class by class evaluation of how people performed during the event, then I think that's as fair of a consideration or an evaluation as any, right? And I think it's probably fair to say, you know, we have customers who don't pay for the RECA and they take service in other ways. One of the great conveniences, it's like sausage making, and I'm not saying it's perfect regulatory theory, but these under and over recovery mechanisms, they just have a nature of socializing. Under or over recovery, we just treat everybody the same. And so you avoid a lot of those really sticky questions. But if we're going to go down the road of developing a new charge, then we have to determine how the special contract customers that don't pay the RECA, how they will pay. We have to determine how the colleges and the big businesses that take direct renewable participation tariff service, how they will pay and how much. And all of that is just looking at, you know, further proceedings and more contention and potentially more interest charges and all of that. But, you know, with regard to the Oxy contract, you know, I haven't examined that contract in detail to know whether they, quote, you know, didn't perform or didn't, you know, were in violation of the contract or the provisions. I have seen evidence in this proceeding and the other witnesses referred to it that there's a certain curtailment amount that's called for in that contract, and they didn't perform to that level. I know that's accurate, or at least that's what's been represented in the data requests. You know, another thing that's an open issue, probably maybe still needs to be evaluated. What I would say that's probably not hasn't been addressed maybe enough yet in this proceeding is we need to be cognizant of the fact, I think, that everybody's worldview changed on February 15th, 2021, right? Everything. SPPs, planning, operations, how they view capacity, NERC, FERC. I mean, you know this, Commissioner. That weather event really opened everybody's eyes, and I would say if you got the principal staff people and company people and utility people in the room that negotiated that contract, I don't think it was ever contemplated that they would call on that curtailment when it was 20 degrees below zero out. You know, the whole system has been set up to shave peak in July, August, or September, and that's how you save money, and that's when costs are high. And so, you know, I don't think that's a straightforward right or wrong type of a question.
Thank you, Justin. Those are all the questions I have. I appreciate it.
Thank you.
Commissioner French.
Thank you, and good afternoon, Justin.
Good afternoon.
I appreciate those last comments. That added a lot of really good context. You know, this is a tough and nuanced proceeding with a lot of questions that require a lot of nuance, and so that's helpful. I think the only other, you've really answered every question I have. I think just one clarification on something you said. I think you can obviously tell something I'm struggling with is if we go down the road of being more granular, not just flowing this through the RECA, because that is how these charges would have normally been charged in the course of things. But if we go down Mr. Gorman's path of trying to more granularly identify the cost causers by class and then create a separate line item charge, there's this debate then about, well, one, let me just say I was appreciative of him recognizing that we're probably going to have to do some recalculations of the allocations. But then, as you referenced, we're going to have to, at the very least, have some sort of additional proceeding on whether that charge includes or should be charged to the folks that don't pay the ECA right now. Do you have a firm opinion on that question as we sit here today, or is that just something that is going to require a lot of additional analysis to decide whether or not, if you aren't using the RECA, whether or not the non-RECA customers should continue to be exempted?
Yeah, that's a good question. And a tough one that I'm probably not going to have a great answer for. I was thinking about that earlier. I don't know. The whole concept behind the Westar direct renewable participation program is that Evergy can, essentially rely on these wind farms, take those customers' usage off of the top of the dispatch stack and essentially, benefit everybody, at the same time as giving these customers a really, an attractive, stable, low priced, almost economic development type rate. Mm-hmm. And so it's a tariff that those customers were taking service under, and so you can ask yourself, well, during Winter Storm Uri, were the circumstances that were contemplated or that contributed to the rationale for the development of the tariff in the first place, were they present during that period of time? Is this a direct class subsidy from one group to another? Those are not easily answered questions, right?
It almost struck me in asking that question of Mr. Gorman and Mr. Ives that the real rub came down to a disagreement between whether you really can segregate out incremental costs or whether Evergy, even though we choose to segregate these customers, Evergy does still bid in all of its generation into the market and serve all of its generation that way. And ultimately, everyone's exposed to those price spikes. And that's not an easy question then. So I'm not asking for a firm answer. I guess I was asking for confirmation that that's going to be a very difficult question if we go down the route of developing a much more granular line item.
Yeah, I mean, from just a few other thoughts is that, one of the things that we've wrestled with in these proceedings, and as you know, the solution for each company has been a little bit different, which is maybe not the most efficient use of everybody's time, but I actually do believe that it results in more optimal solution for each company than just some across the board edict or something. But in any case, one of the concerns I have had and have been expressed during some of these dockets is the question of retroactive rate making, right? You have a filed rate doctrine, you have retroactive rate making concerns. And if that's a real question, that it's an important question. When have you given people notice? Did people go into this period of February 12th through the 16th knowing that, hey, the way I heat my home during this week is potentially going to come back and bite me or harm me or benefit me? Those are all real important questions. So you got special contract customers that have a contractual right not to pay the ECA. Does that mean that they have to pay an ECA equivalent charge? Some of those customers might say, no, this entire process is wrong and illegal. Filed rate doctrine, retroactive rate making, there is a tariff that indicates how fuel and purchase power costs are paid, and that's what we need to use. And if you would have used that, I wouldn't have had to pay. So it's, I don't know how the result of all of that would turn out.
That's as good as an answer as I think I could hope for. I mean, it presents the difficulty of the situation, and I appreciate your answer and participation. I mean, we've asked you a very few questions about what was ultimately a very long and detailed analysis that staff did, and I want to recognize that. And so thank you. And also, but at the same time, I want to thank all the parties for participating here because they've all added something to this very difficult question. So thank you, Mr. Creighton.
Thank you.
Well, Justin, it comes my turn. And I had 3 questions for you. I thought they were great questions. Your answers to primarily the questions directed to you by Commissioner Duffy and in part Commissioner French were so inclusive that they blew my questions away. So they've been answered. And so you're off the hook this time. I'll have to save up for the next time and hit you twice as hard, I guess. But thank you for your testimony indeed. Ms. Mezzantin, Commissioner Duffy, please.
If I could, I do want to say this to staff's testimony. There was a lot of information in here that while we did not talk about it today, it is definitely a real forensic review of what did occur and steps going forward. And it's not like the heavy slogging through this is over. You're in the middle of it, and there's a lot more work to do. And I want to recognize the work that's been done and say that I look forward to the work that will be done with staff and all the parties that are here, because this was an extraordinary event. It did change the lens by which we all look at utilities, just like phenomenal, but a phenomenal change. But I do want to share that this was a good read. This was a good step forward on things that will be coming before us. And that's why I peppered Mr. Ives this morning with a lot of that, because I haven't had the opportunity to have this discussion with the company or really with you, Justin, about your plans going forward, staff's plans with this company in particular. And I just want to say, I am looking forward to it, but I do recognize the extent of the work that went into crafting this document. And I want to thank all of staff for their input. I thought it was very well done.
Well, thank you. You know, I'll pass it along. I'm sure several of them are watching right now. I can't take credit for much of it, but I mean, I had a hand in it. But you know, there, like you said, a lot of hours, a lot of hard work, and there's several authors of that report for sure.
All right, very good. Ms. Mezzantin, do you have any redirect?
Yes, Chair Keen, I do. So I would begin, Justin, by asking, you've heard discussion on the comparison to Southern Pioneer today at the hearing, as well as by reading Mr. Foreman's testimony. Is that correct?
Yes.
And what is your opinion on the merit of using Southern Pioneer's winter weather docket as a comparison point in this docket?
Yeah, so thanks for that. Evergy is not Southern Pioneer, right? I mean, we need to remember that Southern Pioneer is a company that is owned by a cooperative, which is owned by its customers. And we regulate Southern Pioneer like it is a cooperative. Literally, we do. We use a debt service coverage formula-based rate to regulate them like they were a cooperative. Cooperatives have customer information systems and accounting systems that are set up to track their customers own the company. So they're set up to track on a monthly basis how everybody contributes to everything and the development of patronage capital and equity in the corporation. And you literally own the company. It's like they're shareholders. So, Southern Pioneer, right from the very beginning, I mean, literally within the first 3 days after the event, I was on vacation with my family and I took a quick break to have a call with them. And they said, hey, we're thinking about trying to determine how the customers contributed to the actual costs during the event. We had a lot of conversations about whether it would be retroactive time of use rate making, whether it would be appropriate or not with the filed rate doctrine, whether their ECA tariff ultimately allowed for that sort of thing. Ultimately, what was filed was a monthly view, and it wasn't an allocation of the costs to each individual customer based on how they contributed to the costs of the winter weather event. It was not that. It was an identification of the extraordinary costs of the month, of the entire month. And then that per kilowatt hour charge was identified by each individual customer meter, and it became a debt of the customer. There are literally every customer of that company, all 16,000 of them, got a separate bill for their charges. And so that is not what is on the table. Honestly, I don't know of any other investor-owned utility that would even think about doing that. It's a totally different ballgame for an investor-owned utility. And I honestly think at that point you really would be I think you'd have problems. I think you'd have customer classes that would be saying you have no right to charge me based on how I performed during that event. What tariff are you relying on to do that? So anyway, it's not the same. Evergy and Southern Pioneer are not the same.
Thank you. And you've also been in the room today and heard statements suggesting that volumetric usage by class is an indication of what caused the extraordinary costs. Do you agree with that statement?
Yeah, that's a really good question. So during this hearing, I've been really sort of thinking about that, because there have been some pretty strong statements like, the excess usage during this period of time, or the volumetric usage by these classes is what caused the costs, right? Cost causer, cost payer type of an argument. And, that is certainly true. That an argument like that could be made for some of the costs, but not all of them, right? So I do think that's an oversimplification of reality. In that, if you look at the methodology, right? The methodology was an entire month, and it said, how did the month compare to the other 3 months? Well, so in that analysis, you're going to have coal costs, and you're going to have natural gas costs, and you're going to have a whole litany of other types of costs that flow through the ECA. And so for natural gas costs, for instance, Evergy, we did a detailed analysis of Evergy's natural gas purchases in the report, daily, what their usage or what their volumes were, et cetera. And, you think about when Evergy made the decision to buy natural gas on the markets, that's not always driven by that's not always driven by the kilowatt hours or the megawatt hours that are being consumed by customers at that moment. They're doing their best ahead of the storm to line up natural gas purchases, to estimate what usage will be. They buy the gas costs, and then you hope your unit is going to be dispatched by SPP, right? It's because of the difference between the gas and electric day. There's overlaps there, and it's not always perfect. So I really think that some of those statements are a little bit overgeneralized and maybe not perfectly accurate. To say that, volumetric usage, even if you had the dates perfectly, even if we said, no, let's look at February 9th through the 21st, which is generally how we define Winter Storm Uri, by the way, in all of these investigations. I wouldn't even agree that kilowatt hour usage during February 9th through the 21st is per se responsible for or caused the costs that were incurred. Now, it might be a reasonable way to allocate the costs because it's generally in line with cost causation, and but I think it's a little overstated to say that usage from customers during that period of time, quote, caused the costs. And you also think about the sort of macro level events that were causing the cost during that period of time. I mean, the market price of SPP is set based on a 14-state region of everybody bidding into the market, and natural gas prices that were astronomically high for all across the Midwest. So anyway, I think those are some factors to consider when you're thinking about, is this really a deviation from cost causation if we decide to socialize these costs because of the extraordinary nature of the event? And so.
Thank you. And speaking of socializing the costs, does socializing the costs take into account that customers from each customer class were engaged in conservation, maybe to varying degrees, but within each customer class, there were customers that conserved during the winter weather event?
Yeah, I think you could say that. I mean, I think, what the settlement agreement does and what the RECA does is it essentially treats everybody the exact same, right? It treats every kilowatt hour of consumption the exact same. It says there were benefits of conservation. Everybody did their part, the governor and the media outlets and the commission, everybody was doing everything they could to get the conservation message out. And we know that it was successful. I mean, we hear that from SPP. They say, hey, it would have been a lot higher. The usage would have been a lot higher if the conservation message hadn't gotten out. And so it's not like anybody doesn't value the contribution to system reliability that occurred from those conservation efforts. It's just that the settlement agreement says, let's just share those efforts of conservation amongst everybody. We're going to treat everybody exactly the same at a very affordable carrying charge below the utility's current cost of capital. We're going to spread it out equally over everybody over a 4-year period of time. It's the principal policy debate before the commission is that there are parties who think that decision penalizes or punishes them because they are in a class that may have done more than other classes relative to other classes. And so anyway.
And one final question for you today. Does the period of February 12th through the 16th include any weekends or holidays?
Yeah, so February 12th was a Friday. The 13th and the 14th were were both Saturday and Sunday were weekends. And then the 15th was President's Day. And, whether or not you recognize that holiday sort of depends on, different circumstances, right? But I think it's a federal holiday. And so I know it is. So the markets were closed, banks were closed. We were not closed, but we weren't closed that weekend either. But yeah, so yeah, and that's a good point. I mean, it's probably another criticism of using the 12th or the 16th. You're obviously going to have diminished. I don't know. You're obviously going to have diminished activity, commerce activity during certain segments of the economy during that period of time. So
I know I said it was my final question, but I have a second part to the question, if you will. Given that those dates occurred over a weekend and a holiday, in your opinion, would it be more likely that more people were at home during that time?
yeah, I think that's a reasonable assumption for sure. I also thought it was an interesting observation that someone brought up earlier that we might have had a lot of people working at home during that period of time. February of 2021, I know we were, and it's interesting because it's not the sort of thing that they teach you at Camp NARUC or in some of these technical manuals about cost allocation, but it certainly presents an interesting equity consideration when you think about the fact that there may very well have been employees of large customers that were working at home during that period of time and therefore incurred additional usage. Maybe their employer incurred less usage because they weren't eating a corporate office building, or I don't know. It's something, in all candor, I hadn't thought about before this proceeding, but it may very well be an argument towards the idea of socialization as opposed to, individual customer by customer identification or class by class identification. I don't know.
All right, well, thank you. And then that concludes my questioning.
Okay, very well. Mr. Zakara, would you care for recross?
No questions, thank you.
Thank you. Mr. Schulte, recross?
Yes, thank you, Chair. I actually do have some cross, and I know that Coffeyville has been quiet during this proceeding, but I think there is an issue that was raised during the questioning from Commissioner Duffy and counsel for staff that requires a little bit of follow-up and clarity. Regarding Mr. Grady, regarding your testimony that the entire 28 days of February 2021 could be a potential allocation period, the amount of usage during that full month period could be a reasonable basis for the allocation. Have you calculated those allocation figures?
No. I mean, well, let me say that again. So I can calculate it. I know how to calculate it. I think I do have an email that, a sort of not fully polished, maybe not ready to file with the commission calculation that I've done to look at that personally. It was part of my sort of, analytical wrestling, deliberation process as we were going through this docket. So it exists.
Is that something, I believe we're going to keep the record open for a correction to Mr. Gorman's table 1 based on the removal of some customers from that allocation. If we're keeping the record open, is it something that could be added to the record in this case for the commission's consideration?
Yeah, so here's how I would answer that. I'm not sure exactly what I said when I referenced the monthly allocation. I think it might have been something like if the commission wanted to do it, or, if my boss came to me this afternoon, it's not going to happen. But if he did and said, hey, we need to allocate those costs based on, how the classes contributed to the usage for the full month, similar to say what we did in the Black Hills case, then I could do it. I could make those calculations, but that still doesn't get, that still doesn't address the problem, a lot of the other problems that we've talked about in this proceeding, right? If we do that, then we have to create a new line item. And then, I was somewhat surprised. I had not heard the specific numbers or the, how big of a deal it is at Evergy to create a new line item and to add that to their billing system and whatnot. So there are real costs and sort of downsides to that approach. And also we're a signatory to the settlement agreement, and we don't take that lightly. And I think it's a reasonable approach, and it's, that's what we support right now. So, so somebody can calculate that and put it into the record. Or, if there's a commission order that comes out that orders me to do it, or if the commissioners tell me to do it right now on this call, I'll do it, but I'm not gonna, volunteer it. I hope you understand why.
So I have a calculation that I think was based on the email exchanges that maybe you referenced with regard to a rough calculation. And I would ask the commission for guidance on whether I can enter that into the record. I do have it queued up for an email to the parties and the commissioners, if that would be permissible.
Mr. Schulte, is the email you're referencing, was that exchanged between the parties as part of settlement discussions?
All the email's been stripped out. It's just the numbers.
I understand. I think
it has nothing to do with settlement.
I think the numbers
it
were
has nothing to do
provided
with
as
settlement.
I think the numbers were provided to the parties as part of settlement discussions. They were not provided in a data request or anything else more formal than that. So, the parties have had this information for, a month now, and no one has made any specific proposal. So it seems completely inappropriate to put a new proposal in the record at the end of the day today. You guys had the chance to have a witness sponsor something, and that didn't happen. So, I guess I'd object based on the fact that it was settlement discussions first, but then also second, because I just don't think it's appropriate from a timing perspective.
I would support Ms. Dingus on this issue.
If I may respond, I don't think a calculation is a settlement discussion. A calculation does not indicate who supported it or what their position was on it. That's what you're trying to protect by not revealing settlement communications. Calculations, bare calculations, are not settlement calculations. And the only reason I bring it up is because there was a lengthy discussion about how the full month of February is a reasonable calculation. And if there's nothing in the record about what that allocation is, then there's no way for the parties to address it on brief or for the commission to consider it.
Chair Keen, may I be heard on this?
Yes, please.
They do not have a witness. We have two proposals basically in front of the commission. There's no reason at 4:45 of the day of the hearing to bring in another proposal. I support based on, certainly based on Ms. Dingus' comments about settlement discussions. I would also support her on the issue of, we spent an entire day talking about witnesses and proposals that have been made and testimony that has supported them. And it would seem highly improper to bring in a different and new allocation methodology at 15 till 5 on the day of the hearing.
Mr. Schulte? I'm sorry, who sought recognition?
I apologize for cutting in. I would like to add comments as well at this time.
Okay.
Thank you. Staff would like to add that they support Evergy's counsel in the objection to this on the grounds that we do believe these were derived during settlement discussions. We understand the argument that they are just numbers, but where they came from is the issue.
All right, Mr. Schulte, I'll give you one more shot at this, at your view.
Yeah, so the numbers came from the same data requests that that table 1 in Mr. Gorman's testimony were based on. So the source is the same. It's not new information to anybody. And I'm only raising it because there seems to be an interest from the commission and from Mr. Grady.
All right. In terms of the introduction of this proposal as new evidence, I'm going to sustain the objections. I suspect if you wished to add it into your post-hearing brief in some kind of rhetorical sense, you're welcome to do so. But at this point in the hearing, it seems like to me it's it presents a whole lot of issues about the back and forth on all kinds of commentary, and we're not going to be able to subject this proposal to any form of a cross-examination within the time parameters of these proceedings. That's the concern I have. Based upon that, I'd sustain the objections. Anything further, Mr. Schulte, by way of cross or recross?
No, thank you.
All right. USD 259 recross.
No, sir.
Do the commissioners have any further questions before I excuse this witness? Commissioner Duffy? None. Commissioner French?
No, thank you.
All right. I have none either. I believe your time on the stand, Mr. Grady, has come to an end. You will be excused. We appreciate your testimony very much and your work on this entire project as well. Thank you very much.
Thank you.
All right, we are reaching a conclusion, it appears. I want to, before I really carry this point to a conclusion, I want to thank two additional parties that I know all of us will join in thanking as well. One is certainly our court reporter, Robin. Thank you very much for hanging in there. It's been probably the longest day for you, and thank you very much for your efforts. I want to thank as well our IT staff, especially Michelle and Denise. I mean, we haven't made it easy on you, and you've met every test we've thrown at you. So thank you so much for your indulgence of what I think really helped to make this a very meaningful hearing. And finally, I want to thank all the parties to this proceeding. I think this has been an educational and informative effort for the commission. I think probably for the public, for those who cared to listen in. We're grateful to you for your exchange of views. We appreciate the complexity of these issues and the diversity of viewpoints that we've received. This concludes our hearing on the non-unanimous settlement in docket number 21-EMKE-329-GIG. Yes. Someone?
Sorry to interrupt. Just a point of order.
You just barely made it under the wire, Andrew. I'm sorry, go ahead.
Just a thought on when the transcript would be available relative to when the briefs are due. I know that the briefs are currently due on, scheduled to be due on May 27th. Is there a way to link that due date to when the transcript will be due to the length of the hearing today and the volume of evidence that was heard? It may be helpful to have 2 weeks after the transcript is available, if the other parties don't object.
Robin, do you have any idea what your timing might be on this?
I really don't off the top of my head. I'd have to think about it. I know that I'm going to be off for like 4 days. We have a family funeral, but I'm going to talk to a friend of mine and get some help, and I'll get it out to you ASAP.
Well, we appreciate that very much. And I'm sure we'll all try to work within the same confines. Everybody's going to be on somewhat equal territory on that. I was about ready to say, when you interjected, Andrew, that I was trying to remind all the parties that indeed the post-hearing briefs are due on May 27th. That's pretty much baked into the cake here on our process. And a commission order is due by June 27th of 2022. So hopefully, with Robin's assistance, we can offer you as much time as possible. For,
I'm sorry to interrupt, Chair. And as a reminder, I mean, I believe the YouTube recording can be viewed, and while it's not as user-friendly as a transcript, at least it'll give the parties an opportunity to listen to the transcript and kind of work on briefs before finding the actual page numbers and all of that. So I think that can be an additional reference watching the recorded feed to help the time crunch too.
That's a good point. Thank you for raising that. And then at least you'd have a reference point back to a page and line items on the actual hard copy, if that's what you wish. I believe there are no further matters. And accordingly, we are going to adjourn, and we are adjourned. Thank you all very much for your participation. Take care.
Thank you.